in there, but it can be sealed for more. I trust you had a productive evening last night, and I understand that parties have a proposal with regard to at least a portion of Mr. Copeland's testimony. Sorry, I didn't have this turned on. So what I said was, I trust everybody had a productive evening, and I understand that there is a proposal with regard to at least a portion of Mr. Copeland's testimony. So I'll hear what that might be.
Good morning, Your Honor.
Morning.
Simone Hilton for the state of Georgia. Last evening, myself and Mr. Shard had a brief conversation regarding the testimony of Mr. Copeland.
Yes.
I believe the defense counsel have to speak among themselves in order to determine what portions of Mr. Copeland's testimony they are asking to be kept. And so we believe that we need a copy of the transcript.
Okay.
So that they can have that conversation. Once defense counsel has that conversation, then they'll speak with the state about the proposals, and we can move forward from there, Your Honor.
All right. So I don't believe that I think we have the 7th available. Don't know that we have the 11th and 12th yet, but I think we reached out this morning to Ms. Weaver, the court reporter, and I know she has some other people working with her as well. So we'll endeavor to get that to y'all as soon as possible. And she's been pretty fast with the turnaround. So we may even have parts of it by the end of the day. So that seems like a reasonable approach. And then I would think that the next thing we can do, to the extent y'all feel like you want to revisit evidentiary issues with regard to any of the videos, or I don't think you had gotten to the jail calls yet anyway, but with regard to the videos, we can probably do that now. Don't think? Otherwise, give me something else we can do this morning.
Yes, we can do that. If you can, we just need to get that material very quickly to the office, to the courtroom.
All right. Send somebody to go do that, please. And I'm, has anybody thought through yet, and maybe we'll have ready soon any kind of potential instructions for what we're going to be telling the jury about either Mr. Copeland's testimony, well, I guess general Mr. Copeland's testimony, and then I'll entertain what we're going to, I am going to say about the fact that here I am instead of Judge Glanville. But for that, I'm thinking essentially just, I don't know, some matter has required a substitution of judges, and that's about it. I don't plan to tell them really much more than that. They don't need to know why.
Your Honor, given the conversation Ms. Hilton had with the defense last night, in that some of them may be seeking to have some portions of it kept, depending on the court's decisions regarding our respective positions, I don't think we can craft at this point. For instance, if we decided, everybody said, let's just keep it, then we would just keep it, understanding that's likely not going to be the case until we know the respective positions and the court's ruling on that. I don't think we could endeavor to craft it.
Yeah, that may be true. Okay. Yes, sir.
Good morning, Your Honor.
Good morning.
Good morning to everyone. Your Honor, I would, and Mr. Adams can opt out of this if he believes it, but I'm objecting to anything except the unvarnished truth about Judge Glanville. I would like the court to tell the jurors the truth, that he has been found to be disqualified and removed from this case for his conduct. And that's my instruction that I worked on. That's what I'd like you to do.
All right, well, I'll consider everything once I've got everybody's proposed instruction to the extent anybody wants to provide one for me to think about.
Thank you.
And Your Honor, I believe that the statute, if I'm not mistaken, regarding recusal specifically, speaks to the fact that that is not to be made a portion of the case in chief of the main case. I'll get the exact language that I'm speaking of.
All right, great, thank you, I appreciate that. Okay, anything else?
Yes, Your Honor. We also briefly discussed yesterday the exhibit list, talking about how we can resolve working through the exhibit list. And my understanding from Mr. Sharp, I'm not sure if Mr. Kokomo was finished yet, but Mr. Kokomo, who's his legal assistant, and another legal assistant, we're actually working through the same thing that our legal assistant is working through. And our hope is, hopefully the court will be okay with this. By next Wednesday, our legal assistant would have gone through every video to assure we have all of the correct exhibits. But it's taking time because she's literally watching every single time we're in court.
I'm not okay with waiting until next Wednesday. I mean, I'm hoping, and it may be a false hope, but I'm hoping that we'll have a jury back with us by next Wednesday. So that needs to accelerate.
Okay, we will work on accelerating that list to get it to the court. But I believe that they're working on it as well.
Well, they need to accelerate as well if their thought was next Wednesday. I mean, like, I'm thinking this Friday, okay? Which is the day after tomorrow. All right, with regard to, and you're talking about the videos of his testimony, right? Or are you talking about?
No, I'm sorry, I should have been clear. To confirm what exhibits have been admitted and not admitted. That's what we've been working on. No, that's
the giant list of
the giant list of exhibits.
Yes, that's fine. That can be next Wednesday.
Okay.
That's not that urgent. As long as we've got that correct by the end of the trial, that's all that really matters.
Yes, Your Honor.
For that. I thought you meant Mr. Copeland's testimony.
No,
Okay,
Your Honor,
all right. My misunderstanding then. Okay. All right. So with regard to the video interviews of Mr. Copeland, I suspect there are parts of those that the state knows they intend to be using or suspects very strongly they probably need to be using. So can we either come to some form of an agreement about evidentiary rulings that were already made, and or let's figure out what I need to do again?
Yes, Your Honor. I believe after we had the initial arguments regarding some of the redactions, some of the redactions we did concede on. So once I get that list, I can let the
Well, I've already seen those with regard to a couple of things, but I haven't gone through. I mean, I was looking at, for the transcripts I had, the arguments that y'all had already presented, and I saw that there were maybe like a couple, I don't know which, can't remember right offhand which dates I've already looked at, but there didn't seem to be that many that y'all just conceded. Seemed like y'all argued and needed a ruling for most things. But what I'm saying is, having argued it once and having gotten a ruling from a judge who knows what he's doing, whether y'all like him right now or not, do I need to re-listen to each argument and make my own determination, or can y'all agree that, hey, you know, the law, regardless of us arguing our various sides, the law probably is this and we're okay with that ruling?
We believe out of them, we believe, and I'm sorry, Your Honor.
Go ahead.
Out of them, we believe that there might only be two that we think may need to be re-argued.
Okay.
We don't think there's many, at least from the state's perspective.
All right, that's good.
Your Honor, I'm speaking for myself. Yesterday, we received a transcript that was a transcript of an ex parte meeting that occurred on Friday.
Right, this is the
Before the
one.
Monday.
Sorry,
And
I'm
Yes.
sorry, just so that we're clear for the record purposes. This is the transcript I gave y'all at the end of yesterday that reflects Ms. Love had said, oh, yeah, we had, and in court on the record, but ex parte discussion that led to the Monday, June 10th ex parte. So that's what you're talking about?
Let me be more artful. Yes.
Okay.
We were made aware, leading to the recusal of Judge Glanville, that there was an ex parte meeting that occurred on June 10th, Monday, June 10th. We were not told by the state, we're not told by the judge that that had occurred. We found out about it, luckily, and by happenstance. We then demanded a transcript. We complained about said ex parte, inappropriate ex parte meeting. At no point, when the court finally acknowledged that there was an ex parte meeting that occurred on Monday, June 10th, at no point did the court or the state at that point acknowledge, oh, by the way, there was another ex parte meeting that occurred on June 7th. We sat there after finding out about one ex parte meeting and having to drag the truth out. We sat there and the state and their co-conspirator, the trial court, were silent about the first ex parte meeting that happened on June 7th. What happened in that meeting on June 7th? The state went in and disparaged defense counsel. The state, with no one else there, trashed a fellow member of the bar, Mr. Melnick, trashed another fellow member of the bar, Caleb Bumpus, presumed the guilt of all these individuals, including my client, Shannon Stillwell, and all but accused myself and Mr. Steele of being co-conspirators in this YSL enterprise. And the judge agreed. And the judge said in this ex parte meeting, yes, I've observed these things. The judge presumed the guilt of all the defendants. The judge presumed the guilt of myself and co-counsel, Mr. Steele. And all this, people have been saying to me throughout this whole trial, why does Judge Glanville have it out for you? And it never made sense. And I don't assume bad motives of anyone. Why did Judge Glanville, when you did nothing wrong, try to throw you in jail? Accuse you of cussing him out in open court when you didn't do anything? Why does he always tell you, yell at you, tell you to sit down and be quiet? Why does he cut you off at every opportunity? Why did he try to throw Brian Steele in jail for 20 days for doing what was right? And I didn't have an answer. And then yesterday I received, and I appreciate that, Judge. I appreciate someone finally being open about what's going on here. And I received a transcript. And in that transcript, the trial judge, who's not only assuming the guilt of my client, but is assuming the guilt of me and my friend, Mr. Steele. This is gross. This is disgusting. But it's all starting to make sense. It clicked when I read that transcript last night. This is not okay. Nothing about this is okay. These gentlemen have a right to a fair and impartial judge. And I appreciate the fact that you are going to be a fair and impartial judge. But the reality, Judge, is that they don't have a right to a fair and impartial judge starting on witness 76 of a trial after 9 months or whatever it is. They have the right to a fair and impartial judge from the beginning. And this is absolutely gross and disgusting. And the bottom line is there's a lot more discussions that need to be had about this. But the bottom line is, if you ask me, do we need to revisit the rulings of the judge who sits in chambers secretly and talks to the other side and says, yes, I've been observing this. I've been observing this about what's going on in trial. The judge that says, not only I'm going to meet with you on Friday and on Monday, but if we need to talk during the weekend, yeah, we can do that. The judge that suggests handing Mr. Copeland a list of questions.
All right.
Do we need to revisit those rulings? Absolutely, we need to revisit those rulings. We need to revisit everything. This is broken and it's not okay. It's not okay. It's offensive. And it's not your fault, Judge. You didn't do this. I'm not trying to raise my voice at you. I'm heated right now.
I can tell.
My head, steam's been coming off my bald head all night. Nothing about this is okay. Yes, we need to revisit everything. That's my stance.
Okay, thank you. And I think that I understand you being upset, and I understand why you and probably some of your fellow defense counsel on this side of the room are upset. I do not think that everything you said is a fair characterization of what that June 7th transcript reflects. But once we have the official copy, that'll be made a part of the record, and that will show what actually happened, what actually was said. As to any kind of legal error that may have been made with regard to rulings prior to Mr. Copeland's testimony, assuming this case goes forward and assuming there is any kind of conviction, I then assumed that there will be a motion for new trial phase, which at that point I can appropriately revisit things, and then potentially an appeal, at which point those things can be raised. I am considering and reading what y'all gave me yesterday to make a ruling on the substantive matters of that ex parte, and I can consider the June 7th ex parte as well, because I suspect y'all asked me to do that. And if I determine that that is such, that there was coercion that is unconstitutional or structural error, then I will grant a mistrial. If not, then the case will move forward and we can consider again all of the evidentiary rulings with regard to the videos and audios that might be used with Mr. Copeland, because that's the witness that we are on the stand with right now. I would, and I know this is hard to do, but I would like for everybody to try to take some deep breaths and move forward professionally. A lot of what y'all are talking about doesn't make it any easier, but it happened a month ago. I know tempers flared all around, but we need to move forward with this in whatever way it's going to move forward in a calm and professional manner, okay? So then with regard to what we need to do evidentially, I guess I will need to hear from the state as to what y'all think it's very likely for you to be using while you're examining Mr. Copeland, and then I will entertain evidentiary objections, responses, and we'll consider what's coming in.
Thank you, Your Honor. And we're getting that ready as we speak to present to the court. And I'd also like to thank Your Honor for the reminder regarding professionalism. I was going to ask that the court require that we all adhere to that. Being called co-conspirators is not something that I would expect to have heard, no more than I would expect to level an assertion that Mr. Sharp is a defendant. So I'd ask that that all sides be required to adhere to the court's admonition.
Okay, well, again, the transcript will reflect what was actually said in there, and there are some allegations that if I were an attorney and it were leveled against me, I mean, I am an attorney, but you know what I mean, practicing in a case, I would be a little hot under the collar as well. Y'all had potentially legitimate concerns. I don't honestly at this point right now need to rehash all of that. But the reminder is to everybody, okay? And I mean, I've said it, so let's act accordingly.
Ron,
Yes, sir.
I can address the court briefly. I filed a supplement to the Mr. Kendrick's motion for a mistrial this morning. I just want to make sure the court's aware of it.
I am aware of it. I have not yet had a chance to look at it, but that's, got it.
Thank you, Your Honor. Mostly I want to make sure I bring it to the court's attention because again, and I've followed the request of the court to not argue what's already in the papers, but I just want to make sure that the court understands that based on this additional information that we learned about the July 7th meeting, that my client has been consistently denied his right to a fair tribunal. It's been a due process violation. I, like Mr. Shart, am extremely upset having read that transcript. Myself and my fellow outside agitators over here, I assume that they are upset as well. And
I don't think, honestly, I don't think that that reference was to anybody who is a member of the bar. I think that there have been times in this case where members of the public are in the courtroom, which they are, of course, entitled to be, but communicating in ways that are not appropriate.
well, you know, the problem, Your Honor, is that since this was an ex parte meeting that should probably have never taken place, you were not there, I was not there, my fellow outside agitators weren't there, we don't have a video of it, so I have no idea specifically if that was not referred to us. We don't know, do we? We don't know. And what I do know is that I have been arguing with people for 18 months that Chief Judge Glanville was doing his best, that he was trying to rule to the best of his ability based on the evidence and the law before him. And now I have been made to look like an idiot. So
Well,
I do not believe that this trial should continue, Your Honor.
I understand. Thank you. I'll take your supplement under consideration. Like I say, I haven't, obviously you just filed it and I haven't had a chance to look at it yet, but I will consider that in the overall context of the motion I was already considering. And, you know, I don't know that everybody's not going to want to come up here and do their 5 minutes of how outraged they are. If y'all feel like you need to get it off your chest, come on. Now's the time.
Okay, I got one more thing to say there. And then I'll sit down.
Okay.
And I don't believe that this is performative outrage, Your Honor. I
mean, I don't either.
Okay.
I don't either. I already said I understand.
In July of 2023, after months of me complaining about late discovery from the state, which should have been produced in December of 2022, when another terabyte or so tranche of discovery was produced to us, I begged Chief Judge Glanville to put a hard deadline on the discovery being produced from the state. He refused to do so. And you know what Judge Glanville's response to me was when I will tell you. I will tell you what his response was. If this was a civil trial, I would keep this out. But since this is a criminal trial, it's coming in. If this was a civil trial, if it was about money, I would keep it out. But since it's only about Mr. Kendrick's life, that last part obviously wasn't in there. But if this is a civil trial, I would keep it out. I've been a civil litigator for 25 years. I agree that if it was a civil trial, it would be kept out. What I'm shocked by, and I'm new to criminal, what I'm shocked by is that the standard would not be higher in a criminal trial. But what did I say to people? Chief Judge Glanville is doing his best. He is doing his best. And now, again, I don't even know what to say to my client, Your Honor.
All right. Well, you know.
What do I say?
I don't know. Obviously, I don't know what to say right now either. But I think that, while again, I understand frustration, you know, let's be careful about disparaging a respected judge. I do think that he has, and I haven't looked at every transcript yet because they haven't all been produced yet, but I don't think you're wrong that he has been trying his best and doing his best. And, you know, we all as lawyers know that everybody talks about lawyers trying to herd cats, and that's not inaccurate. This is a big case. There are a lot of good litigators on this case, but with a lot of good litigators probably comes a lot of egos as well. And I think sometimes it is possible to sort of get so enamored of your position and of winning a point that you are focused more on that than on backing down and taking a breath and being amenable to hear what the other side is saying. And hell, that's true in our whole society right now. Should have said hell, but y'all, I mean,
You're
all right.
Those were not my words. Those were Chief Judge Blando's words. If this was a civil trial.
Well, I don't know why it was. I don't know what evidence you were talking about. I'm sure there have been evidentiary rulings that have been frustrating to both sides. I will look at the two transcripts and I will make a ruling. And again, I don't think that the characterizations are exactly accurate, but I'll consider it all in context and I'll make a ruling.
Thank you.
All right. Anybody else, or can we move on to evidence? Mr. Steele.
So there are 16, and good morning again.
Good morning.
Good morning, Madam Court Reporter. Ms. Winfrey, there are 16 hours approximately of the video audio you're talking about.
Okay.
And yes, we were going through to dissect objections, but I, and among others, really had an overall objection because the witness testimony, which is before the afternoon of June 12th of 2024, he agreed that he said these prior statements. So over objection, and the way I understand the law, the state shouldn't have been able to put in at all. So I understand what you're doing. You know,
Okay.
We're going with you, but I just want you to know that we're not conceding that the way it came out, and obviously it's going to be redone after, I believe, I heard what you said yesterday, I agree that that's the law. I don't believe that it should come in at all. So before you tell us later, why'd you make me do that?
No, I understand. And I think that Mr. Shard had actually put that particular objection in writing in one of your filings anyway, essentially that to the extent that Mr. Copeland said, yes, I said every one of those things to police officers, but every one of them was a lie. That is an admission that he made the statements. And the defense position, as I understand it, is as long as he acknowledges the statement, then nothing else is a prior inconsistent statement. And I'll hear from the state with regard to that, but.
I add one thing. Just another layer of that. Oh, I'm sorry.
Go ahead.
Just another layer of that is that the issue, the subject matter of these statements is largely the alleged co-conspirator statements, that our stance is that those were not in furtherance of conspiracy either. So
Okay.
There's like two layers
Sure.
of analysis.
Okay, thank you.
I'm sorry for interrupting.
You asked, I let you. But anyway, with regard to, does that make something said that is inconsistent in a prior inconsistent statement? And the state can provide me the law on that. But I think there are times when either an I don't remember or an I don't know or a, well, that was a lie, can still form the basis of making something a prior inconsistent statement. So, but
And Your Honor, I'm going to let Ms. Hilton speak specifically as to the law on factually what Mr. Copeland did say. What he said was, I don't remember anything that I told the police. I keep telling you, I don't remember anything. But if they say I said it, then I said it.
Yeah, I think what they're talking about is he also at certain points said, yeah, I absolutely said that, and it was a flat out lie, and I'm paraphrasing, but
Okay.
that is what they're talking about, correct?
If that's what they're talking about.
Is that what y'all are talking about, Mr. Sharp, Mr. Steele? Yeah, so that's what I would like for y'all to address.
Your Honor, we believe based on two positions, OCGA 24-6-621, which be impeachment by contradiction, as well as a prior inconsistent statement in both that statement, I said all that I said, but it was a lie, or I was trying to finesse my way out of being locked up, would lay the grounds of still allowing the prior inconsistent statement to come in.
Okay, and 24-6-621 is the
Impeachment
by contradiction, and 24-6-613 is essentially prior statements, right?
Yes, Your Honor.
So what I'd like is some case law that represents the proposition that you are asserting, okay?
Yes, Your Honor.
All right. And I don't want it just simply quoted out of a horn book. I would like the actual case law.
Your Honor, if you can give us a moment, just because
Okay.
we need to.
I mean, y'all, when I told you a week and a half ago that I wanted to be going through Mr. Copeland's evidence, y'all had 10 or more get ready for this. So I don't know what y'all thought we were going to be doing, but yes, I'd like to hear it. So if you need a minute to get me the law, go ahead. Is there, we can also do this portion after lunch and do something else right now, because I don't know that we all need to sit in court and do our research. What else could we do that's productive?
Your Honor?
Yes.
I would like to make records. The Honorable Attorney John Melnick is under subpoena. He's in your courthouse, to my knowledge, or to my belief.
Okay.
I believe. If your court thinks that's good use of time, he is going to, I believe, take to task the statements of Lawyer Love.
All right. Well, tell me why that matters, because what may have been the actual truth and that Miss Love and or Miss Hilton perceived and therefore caused them to want to speak to the court ex parte or not, don't really have to be the same thing. And I don't know that it matters whether what they thought was true was actually true.
So objectively, he will go through the emails for the court that were misrepresented by Lawyer Love. He will then, I'm making a record, God forbid there's an appeal as well as for your consideration in this case going forward about calling Judge Glanville as a witness, that he spoke with Lawyer Love. She knew that he represented Mr. Copeland. Lawyer Love said that she did not know that he had denied representing Mr. Copeland.
That Mr. Copeland had denied that Mr. Melnick represented him.
No, Lawyer Love stated that John Melnick had previously denied representing Mr. Copeland to Judge Glanville. And that goes to the heart of why is there a ex parte meeting in the first place? Because I don't know why there was, but Judge Krause over, I've objected to it. And I know you said maybe not, it's dicta, and I agree with that. It did not go to the holding or the ruling. And she didn't make long statements of fact or findings of fact. So I appreciate you saying, I don't know if these are findings of fact, but maybe just surplusage. But if that meeting is the way Judge Krause found, and there is a Honorable Superior Court judge who made that ruling that's cemented in our case, that, I forget the line, but something like it was maybe it should have been done in open court, but the substance may have been proper, something to that effect. If it was done in open court, I would have been able to be there to question Mr. Copeland. I would have been able to be, because the Judge Glanville said, do you want to be, you have questions for your lawyer, the state, or me? If I was there, I assume he would have said, or Mr. Steele. And then people were asking him questions. They were discussing his testimony. Those are things that we get a material right to be present for. So the point I'm trying to
Okay,
make.
well, I'm going to make a
Melnick,
substantive ruling with regard to that, and I don't know how Mr. Melnick is going to add to that. I mean,
because
it is clear to me from reading that June 7th transcript that the questions they had about whether Mr. Melnick represented Mr. Copeland were not, is he literally counsel for Mr. Copeland right now? I mean, they knew he was that because Ms. Hilton said when Mr. Copeland asked to talk to Ms. Hilton outside the courtroom, and they were about to talk, Mr. Melnick either was there or appeared, and Ms. Hilton said, oh, you seem to want to talk to him, so I will let y'all talk privately, which if she didn't think Mr. Melnick were representing Mr. Copeland, wouldn't have done. I mean, there would have been no reason for her to do that. I think that it is clear in context that what they meant by, we've got questions about whether he's representing Mr. Copeland is, and they said it, we have questions about whether he is representing Mr. Copeland's best interests, which as a lawyer, you are always supposed to do for your client. So I don't think they meant literally, has he entered an appearance for Mr. Copeland, or has he represented to us and to the outside world that he is counsel for Mr. Copeland? It was, is he really acting in the best interest of Mr. Copeland? That's what they said they wanted to research and then meet with, or potentially meet with Judge Glanville about.
on the 10th, Lawyer Love said, John Melnick, the Honorable John Melnick, stated that he was not representing Mr. Copeland. And Mr. Melnick said that is just a flat out misrepresentation of conversation.
Okay, well,
So I just want to get the record straight because Georgia law, and I gave you these cases in a footnote. Georgia law right now, and I know I'm very familiar with this honorable court, very in-depth knowledge of the law. So right now, it's if the court finds, this court finds, or an appellate court, that Mr. Williams et al. Had a right to be present, that's at a critical stage of proceeding. It's over. Okay, no one looks at prejudice. But two cases that came out in April, one of them had been in January, but I cited them in the footnote of my motion to just educate
okay,
the court.
well, it's there. I'll
I give it to him, but yes, it's there.
fine, I'll jot it down.
But the Georgia courts are saying that is the law now. We are interested in whether that is wrong,
Okay,
and we need to show prejudice,
okay. With regard to,
like federal.
give me the cases and what, okay.
So I want to make a record of showing it was prejudicial because there were knowing misrepresentations to even have a auspices of a meeting with the judge.
Okay, well,
And I'm not agreeing.
I'm not sure if I follow you though, with regard to, I need to establish that Mr. Melnick was in fact counsel for Mr. Copeland, because even in the June 10th ex parte meeting, Ms. Bumpus was there as stand-in counsel for Mr. Melnick, because apparently Mr. Melnick had said he had a pre-scheduled vacation or something like that, which everybody knew about on Friday or before Friday. And they were saying, you know, how can we actually be representing him, i.e. the best interest, if he's off on vacation when this critically important thing for Mr. Copeland is going on. But here's his standing counsel, Ms. Bumpus. So they understood that technically, at least, Mr. Melnick was representing Mr. Copeland. So, I mean, that's, I can take judicial notice of that to the extent I need to.
I'm inarticulate then, because Mr. Melnick, I believe, is going to have testimony before your court for you to judge credibility.
Okay,
That what was said out of the mouth of the two prosecutors, Hilton and Love, are not true. There's no emails to back up what Love says. Ms. Hilton, there's not this Mr. Copeland, I need to speak with the DA. Those things have been unrebutted. They're just being said. And my point is, without that, then why are you questioning another lawyer's ethical duties? What gives you the right to say that to the judge? And the courts need to know that's not true.
All right. Just like I said to the state essentially yesterday with regard to their motion that suggested that defense attorneys were violating bar rules in the way that they talk to the press, I am going to suggest to the defense that if the state is violating bar rule, or the state violating bar rules in the way that they talk about defense attorneys or in representations that they make to the court, that too is something that they may have to deal with the state bar.
I understand, but I'm dealing with, my concern is Mr. Williams. So I'd like you to make findings, because I think that they go to the heart of, you're entitled to ethical prosecutors. We demand that. Ethical lawyers, ethical prosecutors, and a fair tribunal. That's constitutional, as a fair tribunal. That did not happen here in my advocacy, in my viewpoint, the way I understand what happened. I wasn't there. So I can't talk about, I wasn't in the outside the courtroom when suppose Mr. Copeland wants to talk with Ms. Hilton. I don't know. All I know is what, we do. We come after the fact, we investigate. But I'd like to spread that on the minutes. So I raised that. I don't know, Mr. Melnick's day-to-day,
I don't know that.
But I'd like to call.
I understand, and I don't know that that is ultimately relevant to the determinations I have to make, because again, whether what the prosecutors represented to Judge Glanville was true or not, maybe an issue for another type of tribunal. But in terms of whether it was then appropriate for Judge Glanville to okay the June 10th meeting to further flesh that out is what I need to figure out, right? So it doesn't really matter whether what they said was true for that purpose. It is, they told Judge Glanville what they told Judge Glanville. Was it reasonable at that point for Judge Glanville to entertain the ex parte on Monday, the 10th? Okay. So let me make that determination.
I'd like to call him if you change your rules. Judge Glanville.
You can proffer what he would testify to.
Then I need to, because he didn't see this new transcript, so I need to, he being Mr. Melnick.
Well, what's in the transcript shouldn't influence what's true. So
I would think, no, it doesn't. I would think that he can then say, tell me and I'll tell you, and then you can hear from him if you want, that did not happen. Or that, I want to get it right.
all right, so you haven't talked to him yet about what? All right, well, obviously I'll give you a chance to talk to him before you make a proffer, because you need the proffer to be accurate.
Okay.
All right, so that's not something we can do right now either.
Okay. Thank you.
All right. So what can we do? And if there's nothing, then I'll just go back in chambers and I'll read all my cases that y'all gave me yesterday and I'll make some rulings so I can still be productive and y'all can be productive out here. You want to break for an hour and a half? Okay. All right, let's come back at 11. Doesn't matter to me. Deputies, so if that's fine, but I'm not going to ask them to stay here. They've got a lot of other work to do too. Okay.
case law about your direct question regarding the prior inconsistent statement and whether or not the fact that Mr. Copeland said, I said it, but I lied, if that would be grounds to, would that still be considered a prior inconsistent statement? And Your Honor, I have three cases for the court.
Okay.
I have Green v. State, I have a copy for the court, as well as a defense counsel. You're welcome. Green v. State, which is 317 Georgia 250, which is a 2023 case. Scott v. State, 318 Georgia 855, which is a 2024 case, Your Honor. Sure, Sconyers, SCONYERS, v. State, you're welcome. And United States v. Odom, which is a federal Sixth Circuit, United States Court of Appeals case for the Sixth Circuit. It is an older case. It is a 1994 opinion, and it's 13 Fed 3rd 949.
Okay.
May I approach with those three cases?
Yes,
Your Honor?
thank you.
Oh, sorry, and I'll give it to you.
Thank you.
I gave you green already, Mr. Washington. I gave you green already. Which one did I give you? Okay, you're welcome. You're welcome.
All right, so Green seems to say that if you say you don't remember, that's a sufficient foundation. Is there, and that's the one I've looked at so far, is there one that says, if you say, yeah, that was kind of a lot?
Yeah, so that's also in green, Your Honor.
Okay.
So if you look at page 5 of the opinion, Your Honor, about the 4th paragraph down in the facts of that case, Your Honor, it says during the course of their investigation, officer interviewed Corey Milton, who said he knew Green had a green Camry, that Green told him that a cracker bucked, I shot him, and that it was not Baba, Phil's nickname, who shot someone. The state played this recorded statement interview for the jury at trial. However, before the interview was played, Milton testified that he did not remember an interview or Green telling him about a murder, stating, I be getting high, I don't know. After a break, Milton testified that he did remember telling law enforcement lies to try to get out of trouble and that he would say anything.
Okay.
Milton further testified that the investigators brought up his criminal record, including a federal conviction and state charges that were dismissed, and that during the conversation about Green, Milton was looking for help with his case.
Okay.
And those facts are analogous to what Mr. Copeland has said so far on the stand, that he was trying to finesse his way to get out of trouble, that he said those things, but they were all a lie. And here, our Supreme Court in Green said a witness's failure to remember making
All
a
right, so hang on. You're talking too fast for the court.
Sorry.
Take it down because you're reading.
Sorry.
And then where are you reading from?
Now I'm on page 7, Your Honor,
Okay.
Division 3.
Okay.
And when the court analysis is a witness's failure to remember making a statement may provide the foundation for offering extrinsic evidence to prove the statement was made. They cite London v. State, which is 308 Georgia 63 at 66, page 66 through 67. They further cite Bridgewater, which is 309 Georgia at Penn site 887. Which cited defendants denied recollection of making a statement, provided sufficient foundation for the state to present extrinsic evidence of the statement. Here, the state laid the foundation for the admission of the recorded interview when it asked Milton twice if he recalled making the statement, and Milton responded first that he could not recall making the statement, and then that he did recall but had lied.
Okay.
And so that is plain. And we also have Scaniers that discusses primarily that the state does not now have to go through every single inconsistency,
Okay.
but that we can now, the flat out denial of that statement, Your Honor, allows us to move forward in playing the entirety of the statement, Your Honor, without going into further detail. That's kind of our summation of Scaniers.
All right.
And then Oldham, Your Honor, is a federal case on the same point as the Green case, Your
Right,
Honor.
thank you. Appreciate it. Counter law, counter position from any of the defense attorneys?
Your Honor, I'm gonna let someone that's better than this, than me, respond, like Max Sharp or someone. But I just want to state that the foundational element for this argument doesn't even exist, because we don't know what Mr. Copeland has testified to. I mean, everything he testified to after the 12th is void.
You mean we don't know what he is going to testify to?
Well, we certainly don't, because we
Right. No, I mean, I don't think anybody
we're-
disagrees with that.
Okay.
But what I said was, let's go ahead and things that we think are very likely to still be an issue, given what he may testify to, let's go ahead and try to, hash out the admissibility of. So true. Yes, he may get up there. Who knows what he's going to say? But yeah, I mean, he would have to say something that would give a foundation in order for it. But assuming that he testifies generally in the same way that he did before, which was, according to y'all, and I've seen some of it, that was a complete lie, then we will face this. And so let's figure out what the...
So we're guessing at what he may say based on what he said.
Right, because I am trying to get prepared ahead of time instead of having to do all of this while we have the jury. So yes, absolutely.
Thank you.
Okay.
If anything, I do believe, remember that there were at least 2 full days of testimony from the 10th to the 12th. And
Yeah.
it's the state's remembrance that the I lie started early in his testimony. So,
Okay.
but we can
Thank you.
deal with that as well.
And with regard to that, the court reporter has said that she probably, what did she say in this first field? You talked to her, I didn't.
She is working on the transcripts of Mr. Copeland's testimony. She said by either late today or tomorrow morning, she should have, I believe it's June 10th, or June 11th, and then we'll be working on June 12th, shortly thereafter.
And do we already have June 10th, or did he testify at all on June 10th?
He testified on June 10th, 11th, and all of the 12th.
Did he take the stand? He took the stand at least on June 7th, right?
Took the stand, I asked
Okay.
3 questions in that.
All right. So do we already have the 10th? Somewhere, we'll figure that out. But anyway, it should all be forthcoming soon. Okay, Mr. Steele.
Your Honor, I don't think that the state's cases, what I heard, I did not read them, I just heard the discussion, are what we're looking for, because those cases are, I don't remember, or I was on drugs, or I don't recall, but I found a case is pre the new evidence code.
Okay, so hang on just a second. So I didn't know, did y'all, it's fine if y'all don't have copies of it. You have the site to it. Looking at it, it does actually look like, in addition to saying, I don't remember reading right from the case, he says, Milton testified that he did not remember an interview or Green telling him about a murder, stating, quote, I'd be getting high, I don't know. After a break, Milton testified that he did remember telling law enforcement, quote, lies to try to get out of trouble, unquote, and that he would, quote, say anything, unquote. So it sounds like that is pretty close to what we've got.
Well, okay, maybe I have to study it, but I found a case. Now, my understanding of 24-6-613 is it did not change much of our former evidence code. So I'm about to give you a case
Okay.
from 2011. It is obviously, if you disagree with that, then it should have no application if it doesn't carry forward.
All right, so you just said 623?
24-6-613, if I said
Okay.
for amendment. Prior inconsistent statement.
Okay,
That's what the state's traveling under that.
Yeah.
And prior or impeached testimony or
right.
testimony by contradiction. So I found this case, if you don't mind pulling up,
Okay.
I can email it. Johnson, Johns versus State. Your Honor, it's 289 Georgia at 106. It's Division 3. And that is 709 Southeast 2D 768 2011. And I think that it's on point bad for Mr. Williams, but it says
Okay,
over objection to trial, but we just follow the law. So over objection, the trial court allowed the prosecutor to play the entire tape of an out-of-court police interview of a witness for the state. Johnson urges that the particular statements made in that view, which were inculpatory of Johnson, were inadmissible as prior inconsistent statements because the witness had admitted making them, but testified that he lied to the police. And it says, however, the fact that the witness admits that he or she made the prior inconsistent pre-trial statement does not render it inadmissible. We have rejected that assertion that a prior inconsistent statement is admissible only if the witness denies making the prior statement, but not if he simply disputes the truth of the earlier statement. There is no such denial requirement under, and again, it's I don't want to mislead you, it's under the former
right.
24-9-83. Then I looked at Cummings, which is cited, which is CUMMINGS versus State, which is 280 Georgia, 831. It's in Division 3. It's a 2000. Now we're way back in 2006. That is actually helpful. It does not support the situation that we have here. In that case, let's see, Division 3.
Yeah, so it looks like in that case, he just like refuses to answer whatsoever.
Exactly, which
Okay.
is really obviously, saying I don't remember, I don't recall, I don't, I may have said something. Those things trigger a prior consistent statement. I thought that's what the Green case is that I have to study that the state just cited. But I wanted to bring to your attention that language I just gave you out of Johnson, I thought right on point and bad for my position, but we just tell the truth. So I want to argue with it, but then we always look back. We're always taught to look back on the cases cited, and that former case doesn't promote that position.
So it appears to me, and I'm just looking at Cummings right now too, but so it looks like the defendants, appellants now at, the appellate stage are saying, hey, a prior inconsistent statement is admissible only if I deny making the statement, not if I simply say it wasn't true. And the appellate court is saying, no, that's not correct. You don't have to deny it. Even without a denial, it can still come in. That does not mean the flip is true, that the other part, not simply if he disputes the truth, is not a way to get it in.
I agree.
So I mean, you can take a look at Green, but Green seems pretty on all fours. So I'm thinking unless I hear something that either overrules Green or causes me to severely question Green, Green controls. And whether he says, I don't remember, whether he says, I never made the statement, or whether he says, yes, I made the statement, but it was a total lie, all three of those, it appears under our current state of the law, would permit then the introduction of prior inconsistent statements under 613.
Well, I'm going to read with your permission.
Sure, yeah, absolutely.
Thank you.
All right. Thank you, Ms. Hilton. That was a helpful use of our break. All right, so with that understanding, are there other specific evidentiary issues we want to consider? Or do we want to just jump right into hashing out some of the evidence?
Your Honor, during the course, the state also looked at the redactions that we had previously
Okay.
discussed with Judge Glanville for the states as it relates to the January 11th, January 28th, February 20th, and February 21st interviews.
Okay.
We do not have any issues with the redactions as is.
Okay, and those redactions being something that the defense and you all have agreed to?
It
Or-
was what was
or
hashed out during.
The state of it, okay, so were those hashings out done prior to or after the recusal motion being filed?
It was done. 3 of them were definitely done after the recusal motion was filed.
Okay, well, the one done before the recusal motion was filed, we can go with, however, that ultimately ended up being redacted.
Yeah, I'm trying to recall if the other, I know we were in the middle of playing 2 of them during that time period. I just need to confirm when we actually discussed those 2. So January 11th and February 20th, we actually played those interviews before the jury. And I believe we played those interviews on Monday, June
When?
17th. And
Which would be part of what either needs to get redone or y'all need to make a,
yes, Your
come
Honor.
to agreement on.
And we may have started it on Friday, the 14th, whatever that Friday was before. But for the ones that we did discuss during
Mhm.
that pendency, the state does not have any issues with those 4. As it relates to June 11th, the June 10th interview, there are some we would like to revisit. So,
All right, I'm not sure I follow you.
Okay.
So. What, you say you want to revisit.
so
So I think first it would be helpful to know which ones were hashed out before the recusal motion. And then we can just say, that's what we're going with, because that was prior to any issue. And therefore, we can stay with that. As for anything that was post recusal motion, unless the defense can come to an agreement with y'all about admissibility, we're going to have to redo all of those. So have y'all had discussions yet about, or I thought y'all wanted to figure out what was actually done and what wasn't.
and I guess maybe I misinterpreted what I thought the court wanted us to figure out whether or not there were some that we wanted to even object to. And so we're saying there wasn't any that were done that we wanted to object to for 4 of them. I don't know if the defense has any, for 4 of the interviews, we have no objection to the current state of the redactions based
Okay.
upon what occurred.
All right.
And so that's what I thought I understood.
Okay. And that was January 11th, January 28th.
February 20th and February 21st.
And so you will let me know which one or ones of those were hashed out before. And that is, status quo on that. For the other 2 or 3, whether they were before or after, y'all are good with what was decided, but I'll have to find out from the defense whether y'all are good with what was decided. And if not, what particularly you want to revisit.
Yes, Your Honor.
Okay. And then there was a 5th one.
For June 10th, there are areas we would want to.
And that has not been gone into with anybody yet. Is that true?
No, we did hash out that one as well.
Oh, you just
I just wanted to,
you want to revisit that one.
yes, Your Honor.
Okay. Okay. All right, can anybody from the defense give me anything close to definitive about whether y'all are good or want to revisit the evidentiary determinations made as to any of those?
And respectfully, and I'm not trying to belabor the point, but just need to make a record. Our stance is that our trial judge was not an impartial.
I understand.
And so we don't believe that the issues are just limited to post-serving the recusal motion at this time.
Okay.
So
well,
that's, and we understand.
I am not going to be going back and revisiting evidentiary rulings made before then.
I understand. And I just need to say that.
But yes, for the record, I understand.
This is a very difficult task. I was I think we all were very involved in the negotiations and reviewing of these things. But, as we were doing it, I wasn't taking notes of what I was doing. So I'm trying to put together what exactly was discussed. And part of the problem is we don't have a transcript.
Well, I've got some of the transcripts, but not all of them. So if it would be helpful to y'all to have the transcripts of when the jury's out and y'all are going through, we don't have all of them yet, but I've got certain days. So y'all did that like on the 18th, the 20th, and the 21st, and the 24th, and the 25th, and the 26th.
Yes.
Okay. Which is why I want to use this week to the extent possible to not take 1, 2, 3, 4, 5, 6 different days to do that. Okay, so I'll see what we already have and get that out to y'all. And again, y'all, this is all rough. This isn't official, but it looks pretty clean to me.
And there were extensive emails that went back and forth from myself and other defense attorneys with Ms. Hilton mostly regarding these kind of negotiations where we agreed and didn't agree at the time.
Okay.
So I'm trying to check my emails and make sure I have.
So y'all have those or should have those. So.
And that would be a good starting point. I'm just making sure that what I have is accurate to what she has.
Okay.
I'm sorry, I don't have a better answer for you.
Okay.
Keith Adams on behalf of Mr. Williams. Let me kind of echo what Mr. Short just said. It wasn't very involved, and I'll be candid with the court. I have several boxes, and one of those boxes contains my notes. It got to the point where Ms. Hilton and I were kind of back and forth in court on the day of and sending emails. I don't have those with me. I think what Mr. Short is saying, and if he's not saying it, I'll say it, that we really need some time to kind of get all that together.
All right, y'all.
Yeah.
When I met with y'all, when was that? Friday, a week and a half ago? And said, okay, here's how we're going to move forward. And then gave y'all 10 days or so before we had our Tuesday, hey, we're doing motions now, and then we're going to move to evidence. Y'all should have used that 10 days to be doing this, because we literally talked at that time about we're going to need to go back through some of Mr. Copeland's evidence, and we're certainly going to have to reach what hadn't been reached before. So I know I can't reverse this all back to 10 or 11 or 12 days ago and have y'all then make better use of your time up until now. But y'all, that's what I meant when I said we're going to be doing the evidence this week. So y'all may have a really long night tonight. I do not want tomorrow to be as unproductive as today. And yes, it will help when you have transcripts. And so I, to the extent I can, will get transcripts out to you as I get them. But with regard to like, discussions y'all were already having amongst each other, it wasn't that long ago. So. Okay. All right. So how about another witness? If we can't work on Mr. Copeland right now, is there some other witness that we know is going to also have a lot of evidence that is going to be contentious?
Mr. Zachary, sorry, Mr. Zachary.
Your Honor, Mr. Zachary, there are other witnesses.
Okay.
We've not gone over, well, we have turned over the statements that Mr. Zachary has made.
All right.
I believe that we intend, if necessary, to use for impeachment purposes.
Okay.
There have been no motions in limine regarding any portions of those statements, as we don't know what, Mr. Zachary has not yet testified. And, we would hope that he be truthful and consistent, but we don't know what he's gonna do.
Okay. So for a whole lot of this, I mean, y'all can't really, let's assume that he testifies. Let's assume for everybody who there might be impeachment or other evidentially challenging evidence out there, that they are going to testify in a way that is going to force y'all or permit y'all to use whatever it is. And then the other party assume, well, let me look at all of this is going to come in if I don't object. What do I think I have a legitimate objection to? And then bring that to me. And I know it'll all be hypothetical right now, but that's what motions in limine are. As to evidentiary issues we think are likely to come up at trial. And then we will go ahead and hash those out. So yes, obviously it's a ruling. But if y'all, as the defense, have Mr. Zachary's statements and have taken a look at them and know what you think is going to be potentially objectionable, if y'all want to give me those statements, make those objections, I'll hear a response, and then we can try to get through that. That would be great.
And would the court, is the court asking for a copy of each of his statements? Because we can't provide that.
Yeah, because I mean, I'm going to need those if I'm going to make rulings. So yes. And I know in this day and age, almost everything is a video statement. I also know that for Mr. Copeland, when y'all were litigating the evidentiary issues, you had transcripts available, and that would be immensely helpful. It is a whole lot faster because a lot of the statements aren't going to be anything anybody has an issue with, or you're going to have agreed that's not relevant, it's going out. If you can say that's on page 7 lines, whatever, I can go right to that instead of listening through 5 minutes of that before I get to page 7. So I would love transcripts to the extent we have them. And then of course, if in court, I need to, for a particular reason, watch and listen to the video that is the relevant, cogent part, I of course will. But as to, a 5-hour video when there are 20 minutes that are really at issue, if we can hone in on the 20 minutes via a transcript, that would be ideal. Okay, so is anybody ready to go on Mr. Zachary? Anybody? Does everybody have Mr. Zachary's statements?
Yes.
Okay.
I'll take the hit here.
They do keep sending you up here to be the one.
That's okay. I'll take the hit. So there are thousands and thousands of pages, and probably thousands of pages of transcripts. So we have a digital copy. I'm sure someone has the full discovery here, but we all have printed out copies of his statements. I know my copy
Y'all
has.
are all old like me and you like paper.
Yeah, and because we have our notes on the paper too, and so
Yeah.
I didn't know that Zachary's statements were going to be on the agenda for today. So I
Yeah.
didn't bring the transcripts with all my
Yeah,
notes.
I mean, they shouldn't have been on the agenda because Kenneth Copeland was the agenda today, but
Understood.
okay, yeah, I hear you. You're not ready, but you can be ready soon. So when you say thousands of pages, do you mean period or thousands of pages for Mr. Zachary?
Mr. Zachary, to my recollection, has at least two, I believe maybe three statements.
Okay.
And I'm estimating here, I would say a total of about 9 hours of
Okay.
talking.
All right. Has the state determined whether, so I know, like, for example, for Kenneth Copeland's jail calls, I think you had 11, but you said we're only interested in 6 of them. Have y'all done that type of winnowing for Mr. Zachary and the other witnesses that you're going to be getting to soon?
We have not entirely winnowed, as the court said, down. We have identified jail calls of particular, not witnesses, but defendants that we intended to use. And when the court says particular witnesses.
I mean, Mr. Zachary is a witness, right?
But I don't believe that we have any jail calls from Quamarvious Zachary.
Oh, no, I was just using that as an example of winnowing. I'm not asking about jail calls for Mr. Zachary. I'm asking about whatever you think you might use with Mr. Zachary. If there are 3 statements, for instance, do you intend to use the entirety of all 3 statements? And if not, could you pinpoint for the defense what portions of those statements you intend to use so that if they have an objection to something you're not going to use, they don't even need to look at that because you don't intend to use it. So you can say, here's the portions we think we want to use. And then they can say, only look at those. Here are the objections we have.
I can do that. I have not broken it apart.
Okay.
Segment scientific.
Okay.
As
All right.
I wasn't yet.
At him. I don't know when he's going to come in, but all right. So as a part of all of the work y'all are going to be doing before the 5th, that's going to be part of what you need to do.
And not just for him, just so that.
No, yeah, for everybody, for your next 30 witnesses, and then for your next 30 after that.
And so if, not trying to tell the court how to use the court's time, but if during.
I'm open to suggestions since what I've come up with so far isn't working.
What I can do, what we can do as a prosecution team, over the next, however amount of time the court wishes to allow us, is to identify with respect to each of the witnesses that are co-conspirators. I believe, I know that there are several. We can, and that they will be coming up in the next batch of 30 witnesses. So we can identify, just to the court and the defense, those people, and begin looking at the portions of their statements, their respective statements, that we would anticipate needing to use as opposed to using the whole thing.
Okay.
And so we should be able, over whatever amount of time the court gives us from here forward today, to go through and come back today with a chunk of statements for each of those people.
Okay.
If not all of them.
Okay.
Some.
I like what I'm hearing there, that by the end of today, she have done that for all of them. Yes, I like that. Yes.
I said it, so
You did say it.
You know, there we go. But I not overshot.
You might have overshot. All right. Well, hey, if you can even do it for one, that'll give us something to work on. And I thought you said you could do that before the end of today. Okay. So anyone, are we ready on anything right now?
It's not anything we can go forward with, but Judge Glanville had given me on behalf of Mr. Nichols, a continuing objection to the admission of any of these statements in that they have absolutely nothing to do with Mr. Nichols. So I have a continuing objection to the admission of these statements.
All right.
I have a continuing objection, which has been preserved by Judge Glanville, with regard to both the alleged co-conspirators exceptions and any of the contained so-called statements that were made by Mr. Copeland or the other alleged witnesses that the state has called. Last year, we had motions pending with regard to 801 D2E issues, co-conspirator statements
Right.
issues. The court indicated that, well, it required the state to provide to the defense all of the 801 D2E statements that the state contended it would seek to admit
Okay.
during the course of the trial.
Okay.
That notice was filed on or about by the state on or about, excuse me, November 3rd
Okay.
of last
23.
year,
Okay.
obviously. Couldn't be this year yet, although it feels like it. That state's supplement to state's motion to introduce co-conspirator statements and notice of intent to introduce the same. They only noticed three statements. So anything else that they do now after a year, after 19 months, after a specific motion, after specific requests by every single defendant so that we could hash this out. A year ago, they gave us three. So I'm going to object to any other alleged co-conspirator statements that the state seeks to admit under 801 D2E.
Okay. Understood.
So I want to get that on the record.
Right.
And finally, you know, this is prejudicial misjoinder. There's such a spillover effect as to Mr. Nichols. I had an ongoing motion to sever
Right.
that I want to reallege and reaffirm.
And Mr. Nichols is charged with count one, the gang count.
Yes, that's correct.
Okay. Do you want to, I think I invited you previously to, but if not, invite you now to provide me a proposed 105 limiting instruction, and I'll take that under consideration.
Sure.
And I'll do that for, I know that all 6 of the defendants here are charged in count one, the RICO count. And then other than that, there seem to be sort of 8 or so independent, or not independent, but different acts or sets of acts that some people are charged with 1 or 2, some people are, you know, charged with another set. And yeah, I mean, the people that are not charged with Mr. Thomas's murder might want some sort of instruction that says, other than the gang count, I mean, other than the RICO count, this doesn't go to this defendant. So I'm happy to consider some instruction if y'all want to provide me something to consider.
I will provide you
Okay.
with that, whether you ultimately do that or not. I mean,
Yeah,
this
I mean,
is
I
what
don't know.
we've
I'll
been
hear from
arguing.
both sides. but-
Yeah.
Yeah.
It's what we've been arguing about the whole time and what I've preserved going forward.
Sure.
All right. So we'll get you that
Okay.
soon as possible.
Okay. Now, as to the first point you raised, that only 3 statements were identified in the November notice filing by the state as co-conspirator statements that the state had identified as intending to admit. What does the state have more than that now? And if so, tell me why those should come in despite not being included in the November notice.
So, Your Honor. So, Your Honor, the November notice of 2022.
Oh,
was-
2022?
we provided two 801 D2E notices.
Okay, so is one of them November 3rd of 2023 as?
Yes,
Okay,
yes,
and then you're saying there's another one?
yes, that's November, that was filed on November 30th of 2022.
Okay. And give me just a second, Laura.
Thank you, Judge. In the 2022 notice, we stated that the state will establish the ongoing conspiracy of the YSL Criminal Street Gang Act trial, and any statements made between co-conspirators in the YSL Criminal Street Gang conspiracy that were made in furtherance of the conspiracy are admissible, and we request the court grant the state's motion to permit these admissible statements at trial. What we've seen come up, for instance, during jail recordings, there are persons who are not indicted under this indictment as a co-conspirator that make statements to either a witness or a defendant currently on trial or in the presence of a defendant currently on trial that the defense has alleged the statements are therefore inadmissible, despite the fact that they come within the context of a jail recording that arguably is admissible, that the statements of a particular party are not admissible. Instances like that, we argue, are instances that involve co-conspirator statements.
Okay, so not arguing broadly, conceptually, but arguing as to specific statements. What notice does the defense have of specific statements that are not included in the November 3rd, 2023 notice?
Okay.
Because it's one thing to say broadly, hey, if they're co-conspirator statements, we intend to use them. It's another to say, and here are the ones we intend to use. And if the court had ordered, you need to tell the defense which of these you intend to use, then it's time to get down to specifics.
Yes, Your Honor. So in this particular notice, we did provide
Sorry, when you say in this particular notice, which notice?
the November 6th, 2023 notice.
Okay. November 6th. November 3rd?
It's just, he said it wrong.
It's
just
filed.
6th.
November, okay. You provided us with 3 different statements.
Right.
Right? Okay. Right?
Yes.
All right. So my question is, are there other statements besides those 3 that you believe are admissible in the trial of this case as to any witness?
There are, just one moment.
All right.
And so that we are clear, because there's a difference of opinion. So does the court mean out of all of the jail recordings, out of all of the wiretap recordings, out of any recording that we had, which of those contain arguably co-conspirator statements?
Yes.
There are many. There are many that are included in the.
All right. I have yet to find the notice that y'all are talking about.
The November 6th one? We can
Yeah,
send it to
because
the
y'all,
court.
there are a lot of filings
We can
in
send
this
it to the court.
case, but Ms. Percifield has saved it for me somewhere, but there are already a lot of things in our file also, so.
We'll send it to the court and to counsel for defense.
Laura, what's it called? Where do I find it? Just email it to me because I need lots of assistance. Thank you, Laura. And so was there an order at some point or a direction from the judge to tell the defense which statements you believed to be co-conspirator statements that led to this supplement? Yes, okay. Okay, I mean, if there was, that's all I need to know. So yes, so, okay, now tell me what other statements you believe to be co-conspirator statements and why they should come in now when you were ordered many, many months ago to tell the defense what they were.
They are included as part of the jail calls and the wiretap.
Okay, so they have them.
Yes.
They just haven't been identified as, hey, we think this is a co-conspirator statement. We intend to use it. Okay, well, sure. Well, I mean, I shouldn't say sure. Sure, you can try to, whether you're successful or not, I don't know.
I understood. So when they say they've been provided, they have not been identified in any way, shape, or form. There are thousands
Yeah,
of jail calls involving dozens of people.
yeah.
There are about 3,000.
I think you've said enough. I understand. Them provided in discovery, not identified as here are what we believe to be co-conspirator statements. Thank you. That was kind of what I thought when she said you have them in discovery. All right. So I would imagine that the discovery in this case is beyond voluminous. And at some point in a trial in this day and age, you know, how it's supposed to not be trial by ambush anymore. It's supposed to not be trial by ambush. And I'm not saying you're trying to ambush, but at least as of now, really well before now, you should have identified, I think this is a co-conspirator statement. And honestly, you should have identified out of the God knows how many rooms full of boxes of discovery, here's what we're actually going to use. So to the extent you haven't done that, I've already told you you're going to be doing that by telling us very specifically as to each witness, here's the evidence I intend to use. But that's still weeks down the road. So if you know, well, let me put it this way. Whatever co-conspirator statement you know of right now, let's stand up and let's share it with the rest of the people here so that they can then tonight look at it and say, here's why it's not. Okay? And for anything that you don't know of right now, you need to go home tonight and huddle together and figure out what else there might be. And I will consider whether I'm going to let that in or not. And then if I do, potentially, we'll have to hear as to each of the alleged co-conspirators why it is that you either have or can establish through admissible evidence that they are in fact a co-conspirator, or not in fact. That'll be for the jury to determine, but there's a preponderance from which I can determine. Okay? All right, so who do you know of right now?
Your Honor, hold on 1 second.
Okay. She said, give me 1 second. But yeah, I mean, I know it's a big courtroom and there are a lot of us, so we all need to try to remember to speak into the mics. So maybe the state can, and you're pretty loud, Miss Love, but maybe pull that mic down so it's a little closer to all of y'all.
And so that the court knows what I'm doing, I overheated. And so I had to
By
wait.
which you mean your laptop over.
I do mean my laptop. And I was
Because I've told y'all not to overheat anymore.
So that's what's
Okay.
happened.
Yes, sir.
While she's waiting for that to
Sure.
come up, could I just briefly address a side issue?
Sure.
When we met for the status conference, I
Yes.
believe Mr. Harvey asked you if you would support us when other
Yes,
judges try to
I
drag
recall
us in.
that. And you know what? Immediately thereafter, that very night, a federal judge reached out to me and said, "Oh, I'd like Mr. Harvey for trial." And I said, "No, you can't have him." So
Thank you so much,
Yeah,
Your Honor.
mhm.
But one thing that wasn't clear, or maybe I misunderstood it. You talked about when we say take a 1 week break, that if someone wants to call you in for motions, perhaps they can do that. So you were referencing that week last week where we were out and why we weren't working to prepare
right,
for this.
right.
I was being called into court all over the state of Georgia.
Sure, I'd
Just because,
imagine.
and maybe that was my fault because I wasn't clear whether you would support us if I told those judges, no, I'm in trial. Because we did have a lot of preparation
Yeah.
to do for this week.
Uh-huh.
But unfortunately, I was hauled over all over the state.
Right.
I'm
And
sure
we
maybe-
didn't really talk about that.
Yeah, are you going to cover us for that as well so that we
So-
can work on this trial during those breaks?
Because, I mean, we may just have to decide that on a break by break kind of thing. Because I, for the last 19 months, have been one of those judges wanting several of you in court for cases pending before me on my other docket. I don't want to blanket say anytime we're not here working on the case, I'm still going to protect y'all, as it were. And frankly, I'm sure that all of y'all would like some time to be able to go represent your other clients in court as well.
Absolutely, Your Honor.
So, why don't we take that up kind of as we need to?
Okay.
And if we are not in court, I hope that we will get into a rhythm if this case proceeds to continuation of trial, where we can have enough done that we can say go Monday through Thursday hard and take Fridays off, or take Friday mornings for motions and Friday afternoons off or something, but like a schedule so that y'all know if you are not prepping for the main witness in the case the next morning, that you can go to court and do some other representation.
That would be wonderful, Your Honor.
Yeah.
At least speaking for
Yeah, but
just for
yeah,
myself.
I mean, let's raise it with me when you need to, but
Okay.
I can't give you a blanket answer. right
Okay,
now.
thank you.
Okay. All right. How long are you going to need? 2 minutes, 10 minutes, 1 minute? Okay.
Your Honor, we're going to allow Mr. Atkins to stand up and give to the court the calls that we have identified within the wiretap that contain co-conspirator statements.
Okay.
One of the wiretaps.
One of the wiretaps.
One of the wiretaps.
And Your Honor, this wiretap is a 6,000 page PDF where you can open up audio links. It has the date, the time.
Okay.
90% of them have what they call reference numbers, where while they're watching the wiretap, they'll give it its own 4-digit identifier.
Okay.
Every now and then, the reference number will just say 0. I don't know why. So I think what makes the most sense for purposes of getting, I wanted for the defense to know where this
Yes.
specific audio is. I'm going to give, for most of these, I have the reference number, the date, the time, and sometimes I also have the PDF page
Okay.
on that document. So
Great.
that's how I'm going to reference it for all parties
Okay.
to speak off the same sheet of music.
Okay. Give me a ballpark before you do that of how many there are.
Yes, Your Honor. Let me count these up.
I'm ballpark. 5, 20, 100.
More, they will be closer to 50 to 100.
Okay. So instead of standing there and reading them all, do you have them in writing?
I do. With what I can do is take, a lot of these have notes like next to
Okay.
them of things that stood out. And so what I can do is create a
Okay.
document that has the date, time, reference number.
I would
and
think that would be
PDF
easier
page.
for everybody than making sure they write it all down correctly. Tell me this, what witness is this a wiretap of?
So, Your Honor, there's 2 wiretaps. The specific one I was going to start with
Okay.
is Deamonte Garlington, who is a
Okay.
severed co-defendant.
Right, okay,
And I believe almost the entirety of these wiretaps will come in through Detective Viverito, Atlanta Police Department gang detective, who I think is probably ballpark 50 plus witnesses down the road.
okay.
For this particular portion.
Okay, all right. So there are going to be a series of alleged co-conspirator statements that are in the wiretap of Garlington. I think, I would imagine that the state could speak to me right now about what it is that you will use to establish that Garlington is a co-conspirator. You, Mr. Atkins, will put together the list of all of the details, and you will email that to all of the defense attorneys and the court today.
Yes, Your Honor.
And we can maybe do the litigation of that, maybe that week in August. So I will need at least the portion of the statements that is at issue as well.
Yes, Your Honor.
Okay, so that is one set of co-conspirator statements. You mentioned another wiretap of someone else.
Correct. Of Mr. Sumlin,
And
who
is-
is also, he has pled guilty, but he was one of
Okay.
the 28 indicted defendants in this.
So
case.
you've done your proffer for that one. That one will be easy if he pled guilty.
Yes, Your Honor.
Okay.
Yes, Your
All
Honor.
right, Sumlin. And you can do the same for him.
Correct.
Okay,
And he
perfect.
has less, it's hard for me to ballpark the number.
That's
for him,
fine.
but
I just was like, if it's 2, you can read them out, but if it's some huge chain, then it's easier to just give them in writing.
Yes, Your Honor.
Okay, all right. So that is 2 further potential co-conspirators who have statements we will need to litigate. Whom else?
Your Honor, we have an additional co-conspirator statement from Mr. Copeland, a jail call.
Okay,
That's a part of the 5,
jail calls.
about a
Okay.
portion of the 5 jail calls.
All right, hang on. Is that a surprise to anybody? Do I need to do a back and forth about whether it's fair for that to come in? Okay, that was part of the notice, so that one's good.
I don't think it's a part of notice, but
They don't think that was part of the notice, but they're willing For y'all to say that's good.
But there was just a portion of that call that the defense objected to, but we can talk about that.
Okay, and all right, but y'all have already been litigating that, so I'm gonna call that one good in terms of notice. Whom else? All right, question. So I'm looking at this November 2023 notice, and at this stage, when it was filed, they're talking about witness A. Y'all all know who is referred to in each of those at this point? Okay. Okay.
We filed a supplement that wasn't filed. We gave to them.
Okay.
Witness A.
All right. All right. Can you provide to this judge whatever that supplement was so that I know? Thank you. Do y'all, deputies, do you know whether lunch is here yet for the, okay, why don't we break for lunch? Be back at, how long, practically speaking, do y'all actually need to get everybody fed and restroom breaks and back? Hour and 15? Okay, let's break until 1:15.
Quick question.
Yep.
Hard time finding a statute on recusal that says you're not allowed to say the truth of what happened to the judge. I can't find that.
Okay.
I'll look for that. I'll look for that.
During lunch.
Our reference where it said that you can't use.
Okay.
matter of-
That'll be great. Thank you. All right, we're in recess. Let's say till 1:20 since we've already eaten up like 5 minutes.
All of them, when the court had asked me earlier, whether in all of the jail calls, all of the wiretaps, all of the recordings.
Yes, at this stage of the game, we need to give notice to the defense of every potential co-conspirator statement. And if in the afternoon you can do essentially what Mr. Atkins just did, it's going to be this set of statements, you know, and we'll give you the details of where to find it later. That's fine. But yeah, it's going to be this witness, that witness, and the other witness in these statements as to each of them. Yes, because A, they need to know at this point, and B, we need to know what we need to litigate at this point. Okay. So yes, thank you. All right, in recess.
What's up, guys? Yeah. I'm not going to spend too much time here. I'm going to do another live later when this is all over, updating you guys. But I wanted to make sure you know that the transcript to the ex parte, the new ex parte, the June 7th, is actually attached as an exhibit to Kendrick's motion. Doug Weinstein's supplemental motion has it here. So here, I link that in the chat. And so it sounds like the judge, Judge Whitaker, is going to be ruling on both the propriety of that June 10th meeting, then also this June 7th meeting, because a lot of you probably heard Max Shard and Doug Weinstein talk about it this morning. But somebody says they don't have the whole transcript, but they've got the rough transcript attached as this looks pretty complete. It's called the rough transcript because I guess the court reporter hasn't finalized it, but the judge said it seems pretty complete, and at least this is what's attached as Exhibit A. Here's his supplement that it complains about it, and then when you go down here, looks like a pretty complete transcript. So it wasn't a very long meeting, but it's got it here, so you guys can click on that. So yeah, it sounds like the judge is going to rule on the propriety of that too. I think we heard Max Shard go off about it, and she said that she disagreed with Max Shard's characterizations of everything that was in there. But then she also, when Love kind of seized on that and stood up and when said, could you emphasize that the rules of professionalism apply to everyone, apply to both sides, and said that she was surprised to hear her identified as a co-conspirator from Max Shard. And because Max Shard had said that in the transcript, they're practically identified as, members of YSLs, member of the conspiracy. And Love said she was taken aback to hear herself described as a co-conspirator, and she wouldn't expect to call Shard a defendant either. But then the judge took exception to that and said, well, the transcript will reveal what was said. And she said, when you look in there, she said there was some stuff that would make her pretty hot on the collar, under the collar, if it was said about her when she was practicing law. So I don't know. It's gonna be really interesting to read the judge's final ruling and analysis of this. But here's the clip that I took.
Regarding professionalism, I was going to ask that the court require that we all adhere to that. Being called co-conspirators is not
do I not have the
something
volume
that I
up
would
here?
expect to have
Okay.
heard, no more than I would expect to level it. Regarding professionalism, I was going to ask that the court require that we all adhere to that. Being called co-conspirators is not something that I would expect to have heard, no more than I would expect to level an assertion that Mr. Shard is a defendant. So I'd ask that that all sides be required to adhere to the court's admonition.
Okay, well, again, the transcript will reflect what was actually said in there, and there are some allegations that if I were an attorney and it were leveled against me, I mean, I am an attorney, but you know what I mean, practicing in a case, I would be a little hot under the collar as well. Y'all had potentially legitimate concerns. I don't honestly at this point right now need to rehash all of that. But the reminder is to everybody, okay?
So it was interesting. She said you all may have had some legitimate concerns about why they called the meeting in the first place. So I've got to do my morning stuff here, but wanted to alert you all to the transcript there, and I'm going to do a live later, kind of summing it up and going over everything. So look for the video on that. But yeah, it should be another interesting day. It's funny how the judge is just raring to go, and you guys probably heard the defense being like, "Oh, we're not really ready on the Woody statements," and she's a little frustrated over that. And but I'm beginning to think, yesterday they went through so much stuff that I was like, it sounds like they could have the jury back next week, and I think she still wants to, but with all these Woody statements they need to go over and all that and all the stuff they need to decide, the jury's not going to come back on Monday. I bet it'll be the next week. But anyway, they are back, and what she said 1:20. I'm on West Coast time, so she said 1:20, so it'll be 10:20 here in about an hour. So yeah, I don't think there's going to be a mistrial. I mean, she's already rejected most of the mistrial motions. She's still got the motion from Doug Weinstein pending, which is what he supplemented today with the transcript. But I think, and this is what reminds me of other judges, because Glanville would just let all this extraneous stuff. He lets the process become the trial, where so many other cases and in trials I cover, like the judges cut that stuff out. Like the whole idea that Judge Glanville would be allowed to be called as a witness, or like even the prosecutors would be allowed to be called as a witness. Trials I cover and the judges I cover, they wouldn't like allow that. And I kind of see that with her too. She said point blank yesterday, Glanville's not going to be called as a witness. And then when she was talking about the motion to recuse Love and Hilton, she was saying the idea that they need to be called as witnesses isn't a reason to recuse them. And she was telling Steele that he has the transcript and can ask Woody all these questions about it, and that Love's motivation for doing this and the questions that he wants to ask Love aren't relevant, and she doesn't think it needs to be allowed. And Steele was saying, well, I want to ask about other witnesses that she's done this with. And she said, well, that's more something that you can make an argument about this case, is that, you've heard it from the mouth of one witness that she did this. She can do this in other cases. So it really sounds like she is not going to allow the prosecutors to be called as witnesses. And that's what goes to the cases I've covered. Like this case just seemed to get way kind of out of control in kind of the focus on the procedure. And when you actually get into the facts of the case, it's actually kind of a boring case legally and just like kind of weird. It's all about like the soap opera stuff with the prosecution and the defense and everything. And the judge seems to be a little wary of that and is regulating on that a little bit. But one problem is I haven't read through that whole transcript, but I mean, the judge acknowledges that there's some stuff in there that she wouldn't like either. So I was talking to another judge in Orange County about the whole ex parte thing. And he was saying that he thought that, the reason for the ex parte could be legitimate. But when he read the transcript of the June 10th, he thought it went way beyond what he would have done. And I can see that happening with this June 7th. Like they all just get together and it sounds like they all just got together and just started talking shit about the defense attorneys. But anyway, you guys can read the transcript there, but they're going to be back in like an hour and 10 minutes. And I am going to do another live later, kind of summing everything up, but I just wanted to drop in with you guys and check it out. So I go back to the state seal here, but thank you guys all for tuning in. If you guys can hit the like button if you get a chance, that'd be great. I've been ridiculed by a few people from a certain incarcerated rappers camp about not Young Thug. The Tory Lanez crowd makes fun of me for not having enough likes on the videos. So we gotta show them up, guys. Give them some likes here. Get the algorithm going and get me in the featured videos. So anyway, I will link again to the supplement here. I think the links show up in the comments. I think. If not, go to my Twitter page. It's a link. It's a link on there. But anyway, thank you guys so much for watching my feed. I appreciate it. And if you go to my videos, my latest videos, I've posted some highlights, some shorts too. I've got it on TikTok. So great. Thank you, Dee, for letting me know you see it. I appreciate it. See you guys later.
afternoon. Hope everybody had a good lunch. What were we able to sort out with regard to other potential co-conspirator statements? Identifying those.
Your Honor, we have a list of potential ones.
Okay.
Sort of a broader universe. And I'd like to narrow them down before handing them over. Some of them we have reviewed and they have statements about drugs that we may not want to introduce. So there's a large volume of, for instance, calls that have certain commentary in them.
Okay. So you can identify the statements and you're saying that it may be less than the full statement and you can further narrow that, but you at least at this point have the person and their statements.
Yes.
Okay.
Up to yes.
Okay. Up to what? You can go ahead and continue to explain.
So, and that's the way it is with a number of the jail calls and the calls from the wiretaps that we have reviewed so
Okay.
far.
Okay.
We have, there are some that are left unreviewed, but the ones that we reviewed.
Okay. And for the ones that are left unreviewed, can you identify, here's the person and here's their universe of statements? We just can't tell you what portions yet. Do you understand what I'm asking?
I think I do, and I don't think it's can. When you said, you could just clarify.
Okay, so why don't you do what you can right now, and then I'll ask you the rest of it. So as to what you have prepared, let's go ahead and share that.
So this is much in the way that Mr. Atkins was a list of.
Right.
54 calls.
Okay.
It's similar. It contains.
You don't have to count the number. You can just go ahead and give them the notice.
Okay.
Is it something that you have like a written list?
So yes, it's an internal list of notes.
Okay.
And calls that are identified.
Okay.
So what I can do is provide to them just the calls that are identified.
Okay, so do you want to do that in writing?
Yes.
Okay, so do you want, could you at least in court identify the witnesses?
So. So when you say the witnesses, you mean who we're going to be introducing?
No, that's not what I mean. I mean, who is the alleged co-conspirator whose statement you think you're going to use? And if you have the witness you're going to use, I get it in through, that's great too. But we're looking for co-conspirator statements. So we need to know the ID of the co-conspirator.
So mainly the ones from the Garlington wiretap are the ones that are identified in the majority. That's the ones that we have the majority of. The remaining jail calls that we've identified, they are jail calls of Deamonte, Kendrick, Martinez, Arnold, Shannon Jackson, all of whom are actual defendants who either are currently in trial or who have pled, and Quamarvious Nichols.
I'm sorry, I didn't, number one, I didn't hear that. Sorry, I just couldn't
Okay.
hear it. And number.
Is your mic on?
My original objection was too little, too late. In other words,
I understand.
okay.
I'm just
so-
trying to sort out what there even potentially is at this point, and then, which is harder than it should be. And then I will hear why it hasn't been shared before and why it should now be permitted regardless.
Thank you.
Thank you. So can you say those for people again louder so Mr. Harvey can hear?
Yes, Your Honor. The jail calls, the jail calls of the persons that I have in my hand that we're reviewing are jail calls of people who are currently on trial or who were on trial and entered a plea.
Okay.
So I don't think that that counts for what Mr. Harvey is talking about in terms of co-conspirator statements. In other words, for instance, I have Mr. Kendrick, Mr. Stillwell, Mr. Nichols, jail calls that we had under review by the team who was working on that. And that we've identified calls from that we intended to use.
If I may respond to that, if it's Mr. Nichols' phone calls, the kid has been in jail for a couple of years, number one. Number two, those are his statements. I'm entitled to those under the discovery statute. And if they're just looking at them now, 2 years later, you should, without any question at all, exclude those. I mean, this is,
Okay.
come on, 2 years later.
It is my understanding that everything that my understanding based on your representation to me earlier today in court, that everything that you intend to use as a co-conspirator statement has been provided to the defense in discovery. Is that correct?
Correct.
Okay. And so what we're doing now is y'all asked that it be identified which are going to be co-conspirator statements. So it's not that you don't have it, it's that it has yet to be identified as a potential co-conspirator statement. So with regard to your objection about not having it, you have it, it sounds like. Now, if it's a statement of one of the defendants on trial right now, but it is going to be used against another one of the defendants on trial right now, it is, right?
Yes.
Then it is a co-conspirator statement. So, Mr. Nichols, Mr. Kendrick, Mr. Stillwell, you also said Mr. Arnold and Mr. Jackson. And did you say that both of those people have pled?
Mr. Arnold has pled.
Okay.
And Mr. Jackson is well.
Okay. All right. So the only person you've identified other than the three that are on trial right now is Mr. Arnold who pled.
Right. And there's also Nichols, Kendrick, Stillwell. And I have a jail call from Quamarvious Zachary.
Okay.
We've identified.
That you've identified only now, not previously. So don't tell me that the three that were already identified, they don't have an issue with in terms of it. Late notice, yes. So was Zachary one of the people that had been identified in that November 2023 notice? Because the notice I have says person A, person B, so I don't know who they are.
Right. So not the jail call, the statements that he has made, but not the jail call. So the name, I believe Zachary is either A, B, or C. I have to look
Okay,
at our notes.
doesn't matter who was. Yes, he was identified as one of the people whose co-conspirator statements were you intended to introduce, but the jail call wasn't identified within there.
That is my.
Okay, is the jail call subsequent to the time that you provided the notice?
No, the jail call date is 2015. It's in 2015.
Okay, so is there a reason you didn't include the jail call in the notice that you provided?
When we were preparing the notice, our understanding of the need to extract jail calls that contain this information or wiretap calls that contain this information and identify them was separate from our obligations regarding generally what co-conspirators say.
Okay. Somebody provide me either oral or written or the directive that the court gave to the state so that I can figure out whether that was a reasonable interpretation.
And we're going to
Okay.
get that for you. And at the time that we were under the obligation to present the co-conspirator statements, we were still, and the court was aware, we were still listening to, because there was an ongoing commentary about the jail calls and the number of them and identifying them. So we were still listening to
Okay. So at some point, presumably you completed your listening. I mean, I know they're still ongoing, so I'm not talking about a jail call somebody did last night, but.
Even
Okay.
all of the ones.
Do you understand? I'm sorry to interrupt you, but let me back up and ask a different question instead. Did you understand that you had a continuing obligation to notify of co-conspirator statements, even if it didn't include jail calls and wiretaps?
Yes.
Okay. And with regard to whether there was some other understanding about jail calls and wiretaps, I'll sort that out later. Let's, at this point, are there other people who you think are co-conspirators, who you think you have co-conspirator statements for that you are potentially going to want to admit in this trial? And let me direct your attention to, because this might help you a little bit. You, a couple of days ago, provided at the court's request to the court, and I assume to opposing counsel, a kind of modified list of witnesses still to go. All right. And you have at least a broad outline of evidence you expect with those witnesses. And some of these people you have actually identified specifically as co-conspirators. So, I mean, can we go through that and at least with regard to those people, see whether, yes, in fact, there is potentially such a piece of evidence? All right. So if everybody wants to follow along and pull out your state's witness list, the first one that I notice is number 3, Antonio Sledge, who you say is a co-conspirator. And then on your evidence, you have listed a defendant interview and a jail call. Right. Could that potentially be?
Yes.
Okay.
Yes.
So we can add Sledge to the list. Then Zachary, you mentioned, so he's already on our list. Now, some of these, I just don't know, but there are a lot of them that have interview or something like that over to the side. I mean, somebody like number 7, Kenya Morton. I don't think she's a co-conspirator, but okay. And then Arnold, who's number 27, you mentioned. How about number 35, Wooney Lee, who you have labeled as a co-conspirator?
He is.
Okay, and are there potentially co-conspirator statements from him?
So unless what we have of Winnie Lee consists of social media
Yeah.
evidence. So arguably, if that could be considered co-conspirator statement.
Say better to say, yes, I think so, and it not be than the other way around at this point. I think it was 35, 33. Says 35. Oh, no, it says 35 on mine because I got what, today maybe? Or yesterday afternoon, an amended witness list that adds a few people.
And Your Honor, for the record, it added 2 custodial records for
Okay.
Sprint and T-Mobile.
Okay, so anyway, Winnie Lee, either number 33 or 35. How about, and you mentioned someone earlier this morning, and someone y'all already had notice of from November of 2023. So someone's, okay. I mean, that may be it in terms of, in my review over lunch, what I noticed to be pretty obvious ones. Are there other ones?
And Your Honor, I think I took it for granted, but all of the 6 co-defendants currently on trial, their statements, their social media, and the jail calls that they have, that we have of them,
Okay.
would be
All right.
considered co-conspirator.
All right, and I'm think that with regard to the 6 co-defendants on trial, it is, I mean, pretty obvious considering that there's a RICO count as well, that the state considers those people to be co-conspirators of each other. It still might be helpful to identify statements, but with regard to deficiency of notice as to those people, I'm going to say that's okay, that's kind of within the context of there being a RICO count against them all. That notifies the defense that at least you think they're all co-conspirators. So if you can identify the statements as well. So that leaves, I guess, so does that mean that there are no others other than the ones we've run through just now?
I want to say that that is accurate. I want to be accurate before I say that that's accurate.
So while she's making sure she's being accurate now, somebody else can tell me, so on the notice that is from November of 2023, the two people who are they? Zachary and Sumlin, the people that are identified as like person A and person B? Everybody seems to know except me at this point. I mean, y'all know at this point. So how about somebody on the defense side tell me? And you don't even have to say who's who, just. Ms. Weinstein, you're looking at me like, I know, but.
I'm looking at you like, this seems like a job for Max Sharp.
Apparently it is, because here he comes.
I'm looking at, am I correct that you're asking about this notice of the three?
Yeah, there's a like, I don't know what it says, witness A and witness B, or person A and person B. And then y'all said, or she said, there was a supplement that actually identified who those people were. So.
So, Your Honor, witness A was Mr. Copeland, and in that notice, we talk
okay.
about the statements that Mr. Garlington made to Mr. Copeland. Witness B was Quamarvious Zachary.
Okay. All right.
And he's talking about statements that were made by
All right.
defendant Stillwell and defendant Kendrick.
Okay.
And
Yes.
I agree with 1 and 2. 3, I'm not sure has played out in actual testimony.
Okay. Do y'all know who 3 is?
I think it says Donovan Thomas Sr. to his brother, but that wasn't co-conspirator.
There's only an A and a B that are like not identified people, right? Okay. Okay.
But 3 is not a co-conspirator statement, correct? Okay,
Okay.
so there's only 2 co-conspirator statements, alleged co-conspirators.
Okay. All right. So with regard then to
Deamonte Blaylock, Your Honor, there are statements that are made, well, there's social media that we have identified. Deamonte Blaylock is a defendant in this case who's been severed.
Severed. Okay.
He, social media from the incident listed on the indictment that he was already tried for with one of the other defendants currently on trial.
Okay. And Lee is also a severed co-defendant, right?
Lee, yes.
Okay. How about Sledge?
Sledge is a co-defendant that already pled guilty.
Okay. All right. Yes.
You might want to know Mr. Lee, he resolved this case.
Okay. But I mean, he was at one point part of this indictment, the big indictment. Okay. All right. So then really for everybody that was a part of this indictment, everybody was charged under the RICO count, right?
Yes.
Okay. So it will come as no surprise that the state thinks they are co-conspirators because the state literally alleged that in the indictment. at this point, there is an objection that they don't have notification of what the statements are. And we are several months in. How quickly can you get to them the detail about what you think co-conspirator statements you intend to introduce? Go ahead.
Your Honor, not certain what amount of time the court's willing to allow us to identify anything not already identified or in the indictment. I don't know if a week exceeds what the court is willing to give. It's what we would ask to identify within the discovery already provided.
Right.
Identify specific statements that are there. We would ask for a week to identify that.
All right. Understanding, Mr. Harvey, your objection to delayed notice, I am going to overrule that objection right now to the admission of the evidence. We, of course, still need to know what the actual evidence is. And a part of the basis for me overruling that is that it appears that the whole trial has kind of been operating on a rolling basis with regard to the evidence. And there have been orders even that, hey, you know, every other Friday, let's talk about the evidence that's coming in for the next 2 weeks. And so if that's been the understanding, then so be it. But I want that to stop right now, which is why we are going through in what I consider to be painstaking detail, because this really should not be what the court is spending its time doing. This is what y'all ought to be doing on your own. But I want us to get on a track where the litigants know what is potentially coming in against them, less than here's the universe. And I want us to be efficient, but I don't want y'all, anybody, either side, having to try the case sort of, you know, blind or practically blind. So let's, now that I hope we all are getting a better understanding of how it ought to work moving forward, I am going to give y'all, because I've given y'all a lot of other tasks as well, 1 week until next Thursday to get all of that in detail, including anything in wiretaps, including anything in jail calls to the defense. Okay. You look like you want to say something, Mr. Steele. Okay. All right, you're welcome. Okay. So, what else can we get done today?
You know, just to address a matter that the court asked me about before lunch. The court had asked when I represented that my understanding, if I'm not mistaken, was that the matter of disqualification of a judge was not competent evidence to be used in the trial. I think I said something akin to that.
Yeah, and you said you had some kind of law that you could provide to us.
What I referred to was Georgia Uniform Superior Court Rule 25.6 and my understanding of it.
Okay.
If it's different than the courts, then that's not unusual. But the last 2 lines of the rules say that if a motion to recuse is sustained, the selection of another judge to hear the case shall follow the same procedure as established in Rule 25.4. Any determination of disqualification shall not be competent evidence in any other case or proceedings. So the way that I understood that, and of course that rule is, cited in other cases, for instance, not for the proposition that the disqualification is not competent evidence. It's just cited in a block cite in Evans versus Williams, 341 Georgia App 226. But that's my understanding. If my understanding is not in line with what the court's understanding is, we would have other arguments against the idea that somehow the recusal of the former trial judge is competent evidence and in some way relevant to whether or not the defendants did or did not do what they are alleged to have done.
Well, it's not relevant evidence as to whether the defendants did or did not do what they're alleged to have done. It cannot in any way be evidence of that.
I mean, I was as to relevance. That was
Okay.
why I was saying.
All right, so relevance will be a separate issue from whether it is, and I can already anticipate the argument because I would make this argument. What you just read says any other case or proceedings. What does that mean for the case that it happens in? So I think we probably need a little bit more research.
And that is what I sought
Okay.
to do over the lunch hour, but I did not find any Georgia case law that
Okay.
elaborated on, I didn't find any case law that elaborated on
Okay.
that. And so that was,
All right.
that was where I stood.
Okay. Well, thanks for letting us know what it is you were referencing, and I'm not sure if it actually answers our question or not. And it might not need to, because the relevance issue may be what answers that question, because we cannot, well, and it may be that, I don't know, I will entertain whatever y'all want to submit on that. Either competency-wise or relevance-wise, although I think I pretty fully understand the defense argument on it, but, okay, thank you. So I know we're not quite ready on the Copeland evidence. I think we have sent out some of the transcripts we've got already. So we're not ready on Zachary yet. Are we ready on any part of Zachary? How about the part y'all had notice of? Yeah.
I'm a little confused.
It's not even showing that I have a message, but okay. So that's a problem. Yes.
So regarding Zachary, when we're talking about the co-conspirator statements, we've been talking about Mr. Quamarvious Zachary in different kind of contexts here. We've spoke of him having approximately 9 hours of statements.
Right.
And we're also speaking about him in context, as I understand it, with the co-conspirator statement. One statement allegedly stated by Mr. Stillwell to Mr. Zachary, that we caught nut down bad. And then another statement allegedly made by Mr. Kendrick to Mr. Zachary saying we caught nut down bad. Is that correct? Those are the entire co-conspirator statements to Zachary that we're talking about right now.
Judge,
Yes.
Zachary's interviews, the entirety of those interviews and everything that he alleged that a co-conspirator told him in those interviews are statements of co-conspirators we intend to use in this trial. So he has said, and we identified that because I thought it was pretty specific as it related to the Donovan Thomas murder, what it is that 2 defendants currently on trial are alleged to have said.
Okay.
But within those interviews, he talks about other co-conspirators and acts, for instance, the shootings, the buying of the shootings of one of the incidents that are alleged as an overt act in this indictment. He talks about his role providing guns to members of YSL.
Okay,
and
so the
statements
answer
to-
is no, it's not just those 2.
right. It's the
Okay.
whole state.
No, it's not just those 2.
Right.
It's
Well,
all-
some of
And
the stuff-
so,
my understanding is the state is saying, and I don't know if this is true or not, but the state is saying at this point, to the extent that they know, that Mr. Zachary's taking the stand. So that's what I understand him saying. And so him saying that he provided guns to people is not a co-conspirator statement if he's taking the stand.
True.
I'm saying what the state is saying is a co-conspirator statement involving Mr. Zachary. The only thing we've has been identified to us is those 2 statements,
okay.
which are clearly, in my opinion, spilling the beans. I mean, we're in the same predicament as the other. That's going to be our stance, but I don't know. I can't answer the other statements that I have not been identified specifically.
The statements that the statements that Quamarvious Zachary gave to the police, I'm certain everyone is aware within those statements contains statements made by other people within YSL. When he's talking about the acts that were committed, he is talking about conversations at times that he has with other members of YSL. He may, for instance, at one point talk about what Antonio Sledge told him to do or something of that nature. Antonio Sledge's statements to him would constitute a co-conspirator statement. So to the extent that we have given to them the interviews of Quamarvious Zachary and have noticed them that he is our witness, our position is that the interviews and what is within them, it is a discrete set of information that they have noticed that we are using that.
All right, so I think I hear you saying that with regard to anybody named with at least 1 count against them in this indictment, which is everybody in the indictment, that anything that they say to anybody is a co-conspirator statement, potentially, because they're co-conspirators with the other co-indictees. And anything that they relay was said to them by another either indicted person or person who has admitted in judicio to being a member of this gang is also a co-conspirator statement, and that the defense is basically on notice of that anyway?
If it is contained within an interview that we have given to them,
Okay.
yes. If it is a statement that is made to someone alleged to be YSL, yes. If it is a statement that
Not
is-
just alleged to be YSL. I mean, if you're saying they've got automatic notice of this, they need to, it
Okay.
needs to be more than somebody's alleged to be YSL for them to, if you're saying, hey, my notice already based on this indictment and me giving these statements over is sufficient notice.
The only reason I said alleged is that the people here have not, we're on trial. So.
Right, but they're co-indictees.
Yeah.
So I was talking about people other than the co-indictees.
Yes, I see what you're saying. Yes, any statement, yes. To answer the court's question earlier, then yes. To the extent that we have given them that interview, yes.
All right, and so are you seeking to say, and maybe this is where Mr. Shard is asking for some clarification, that for all of those people, which is essentially everybody we talked about, that the most detail you're going to give them is you have their statements,
No.
or are you going to break it down further within the next week?
We will break it down further, but there are only, I think, the people who've pled, and Quamarvious, Zachary, and Kenneth Copeland, who were not indicted, that
Okay.
fall up under that umbrella.
Does that answer at all your question?
Can I explain how it really doesn't? And it's kind of to move from the theoretical,
Yep.
the theoretical to the reality.
Yep.
The reality is these statements. For instance, Mr. Zachary gives a proffer. There's like 4 district attorneys and probably 4 investigators in a room with Mr. Zachary and his attorney. The district attorney, it's really the investigators are just peppering him. Well, tell us about the Lil Wayne bus shooting, or tell us about the shooting on, someone's house.
Mhm.
And to the extent that, now I get it if Mr. Zachary's saying he was there for a certain event, but there's discussion of a lot of it. The shooting of the convenience store on Cleveland, I'm just making this up,
Yeah,
Cleveland
sure.
Avenue. And I'm just going to use my client's name because he knows I don't mean anything by this. Well, yeah, I think Shannon did that. I think Shannon did that, and that's my understanding. And there's no real. These aren't lawyers asking the question, and there's no indication of what he's basing it on, who told him, who he's saying told him,
Right. So
and
you
everything
need
else.
to know in
Right.
more detail.
Who
Is
the
the
source
state,
is.
well, is the state planning to use, I think Shannon did that.
Right.
Is that
and
what you want to know, so that we can then drill down on, is there any basis for that coming in?
Right. I
Is
need
that
to
what
know
you mean?
what the statement is. If the state knows, now obviously if the statement says, Mr. Huey told me this, then I understand that
Yeah,
he's saying the
okay.
source is Mr.
Okay.
Huey, but there's just so much information that's just
Okay.
like being thrown out
Okay.
with no declarant, no identified declarant.
Sure. Okay. So first things first is you identify within the next week what parts of each statement you intend to use, because it may be that you are not going to use, I think Shannon did it. And so if that's the case, we won't worry about it any further. So identify them. And if you can also, before the end of the week, before a week's time is out, identify the source. If it's not readily apparent, do that as well, but at least get them each statement. And so we'll go from there. Okay. All right. So what else do we need to think about? Because I mean, and I hope we can actually go through more evidence, but all of what we're doing right now is productive, even though we're not hashing out the details. We're at least winnowing, narrowing, which is good. So I don't have an agenda anymore. My agenda got hijacked. What else can we do that's productive today? Anybody have any ideas? Mr. Steele. Okay.
I could get you brief very fast, but I argued this before the recused judge and it was denied. Former judge would not give me a certificate. I took it to the Court of Appeals of Georgia under the collateral order doctrine. I lost. And then the Supreme Court of Georgia denied cert.
Okay.
But there's a ruling on it.
Okay.
So if you don't want to rehash it.
I don't even know what you're going to ask about.
The indictment is fatally defective.
Okay.
So I could take a quick count, if you don't mind, right now, and it should apply to,
Okay.
definitely applies to Mr.
All
Williams.
right. I don't know. I mean, if it is something right offhand, if it Go ahead.
Okay, well,
Go ahead.
it's a general demur. I was going to do it again at appropriate time, but since you asked.
Since we don't have anything else to do right now. Okay.
So in count 56,
You know what? Let me grab my copy of the indictment. Okay, count 56.
I'll get you the page.
Give me a minute.
It's page,
Okay, got it. Page 90.
okay, so that charges Mr. Williams, I'm just using this as an example.
Oh,
It
okay.
repeats, charges Mr. Williams with participation in criminal street gang activity. And it gives the date range. And it says the essential elements need to be there while occupying a position of organizer, supervisor, or other position of management or leader of the criminal street gang. YSL did engage in directly or indirectly or conspire to engage in any one of the following acts of criminal street gang activity. And that lists murder, aggravated assault with a deadly weapon, armed robbery, hijacking a motor vehicle. Sorry, I apologize, Ms. Winfrey. Okay. Participation in criminal street gang activity for that said accused in the county of Fulton and state of Georgia on and between the 12th day of May 2018 and the 8th day of May 2022, while occupying a position of organizer, supervisor, or other position of management or leadership of the criminal street gang YSL, did engage in directly or indirectly or conspire to engage in any one of the following acts of criminal street gang activity of YSL, to wit, murder, aggravated assault with a deadly weapon, armed robbery, hijacking a motor vehicle, sale of marijuana, possession of marijuana with intent to distribute, theft by receiving a firearm and possession of a weapon by a convicted felon contrary to the law. The state, good order, peace, dignity are up. They're going to repeat, but Your Honor, my belief is that the grand jury, by and through the Fulton County District Attorney's Office, did not allege a material element. There
Okay.
are 4 material elements in violation of criminal street gang activity. And there's going to be a jury instruction that the court, one day is going to give to the jurors. There is a jury instruction on this crime. I'm trying to get you the pattern jury charge. It gives the essential elements. And that would be pattern jury instruction 2.02.25. And there's also case law that one of the essential elements is that the crime was committed to further the interests of the gang. That is omitted in count numbers 56 and 57 from Mr. Williams. There are other people here charged, Your Honor, that has the same issue,
Okay.
but different count numbers. And the way I understand the law is that the fact that the statute does not give the mens rea, every crime has to have the mens rea attached to it. and that when the legislature or Congress does not include the mens rea, the courts say that the omission from a criminal statute of any mention of criminal intent should not be read to dispense with that essential element. This rule of construction reflects the basic foundational principle that wrongdoing must be conscious to be criminal. And here, and that was, I'm sorry, under MORISSETT versus United States. That's 342 US 246 at 252 1952. It's also explained in Elonis, ELONIS versus United States, 575 US 723 at 734. It's a 2015 case in Division 2.
I'm sorry, 575 US.
723
Okay,
at 734. It's a 2015 case.
okay.
It's in Division 2B. And that specifically says that the fact that the statute does not specify any required essential element, including mental state, does not mean that one does not exist. And here what happened is there was a challenge years ago under Rodriguez from this courthouse, Georgia Supreme Court, said in order to save, or that it is a constitutional statute because it's not a denial of freedom of association, because you don't have the right to commit a crime in furtherance of the gang.
Mhm.
That became an essential element. That changed our jury pattern instruction.
Yeah.
And our grand jury did not, in our case, did not allege that.
Okay.
So I know that there's a lot of argument about, well, this is a gang case, and then 418 kicks it, 24-4-418 kicks in. But I believe that the charges for the gang is not appropriate. I
And
wrote,
did you say, I'm sorry, did you say that, what did you say the Court of Appeals did?
they didn't take it up.
They didn't take it up,
I
okay.
didn't get under Dukes, DUKES. I don't have, Judge Glanville denied a certificate.
Oh, okay.
They never.
I thought you sought, but you did not secure a certificate. So then you took that up under the collateral order rule and,
Did not, they said it's not a collateral order. I
okay.
needed a
All right, so they
certificate.
gave you an opinion on the merits of, is this a collateral order thing you can take up?
And then
Okay,
and then they dismissed the appeal. So there's no
right,
rule of the case.
okay.
So that is, a couple of counts for Mr. Williams. He has 6. Then the conspiracy, which we're talking about. Okay, I'm sorry.
So you said that with regard to counts 56 and 57, it is not alleged.
I promised that.
Okay.
in those
And
two counts.
are there other counts that are alleged against your client, Mr. Williams, where that is an issue?
Yes, there's an
Okay.
essential element in count 1,
Okay.
which is the RICO count. And I compared it, I just did it because, it's such a well-known case, to the Donald Trump indictment out of the same grand jury courthouse.
Uh-huh.
Nowhere in count 1 will you see that any of these individuals have been charged with joining the conspiracy knowingly and willfully. It is not in there. And that RICO conspiracy count starts, I think, at page 12, but hold on.
All right. And so you're saying nowhere in, I'll read it. It's pages 1 through 68 of the indictment. But no, I'm sorry, 12 through 68. You're saying nowhere in that 50-something pages does it allege any of this was to further the interest of the gang?
No, I'm saying that it's a different.
No, that's not what you're saying, or no, it's not in there.
I'm doing a different issue in that, in
Okay.
count 1.
Okay.
The conspiracy.
All right.
The grand jurors charged that Mr. Williams and the others who are here, also
Mhm.
the others who are not here,
Mhm.
unlawfully conspired to acquire and maintain indirectly and indirectly an interest in and control of U.S. currency and other personal property through a pattern of racketeering activity
Mhm.
in violation of OCGA 16-14-4A, as well as 4B, as well as B. But what happened there is, I went through it hard. There is no allegation by the grand jury that Mr. Williams or anybody knowingly and willfully joined the conspiracy. And under Cotman, which is COTMAN versus State, which is 342 Georgia Appeal, 569, it's in Division 2.
Okay.
The 2017 case, that is a teacher from the APS trial. It was also a RICO conspiracy case.
Mhm.
The Court of Appeals of Georgia held that in order to commit a conspiracy under the RICO statute in Georgia requires proof of the material element that the accused knowingly and willfully joined the RICO conspiracy. That is also in MacArthur, which is MC-ARTHUR versus Beach, which is BEECH. Haven, which is HAVEN Baptist, BAPTIST Church of Athens. Your Honor, it's 368 Georgia Appeal, 525, it's in Division 3. 890 Southeast 2D, 427, that's a 2023 case. Cotman specifically wrote that under Georgia law, a person may be found guilty of the crime of RICO conspiracy if that person knowingly and willfully joined the conspiracy, which itself contained a common plan or purpose to commit two or more predicate acts. There's also Wiley, which is WYLIE versus Denton, DENTON, which is 323 Georgia Appeal, 161, it's in Division 1. It's a 2013 case where our second highest court wrote the material requirements needed for a conspiracy under the Georgia RICO statute is for the person to knowingly and willfully join said conspiracy. There's another case called Z, like in the Honorable Lawrence Zimmerman -space, SPACE, Inc. versus Dan Tanners, DANTANNA CNN Center, LLC, and that's at 349. Georgia Appeal 248. It's a 2019 case. And what I used also was, I just looked at Donald Trump's indictment. I was interested in it.
Mhm.
He is not only the former president, but the other alleged co-conspirators. They are charged several times with knowingly and intentionally joining this conspiracy. And it's not here for Mr. Williams. And mens rea is a material element of the crime and must be alleged in the indictment. That's in Eubanks, EUBANKS versus State, which is 317 Georgia, 563. It's in Division 4. It's a 2023 case. So, you know, as you're going through this, if you're going to reconsider it, I will bring it up later, obviously, because I believe at a directed verdict motion, that would be relevant as well. But, you know, I don't know what it's like ever to be a judge. And I certainly don't know what it's like to come into a case like you're coming in. So if this helps, this is ripe under State versus Heath, HEATH. Once the jury is sworn, a general demurrer can be made orally or in writing. I actually put this in writing.
Okay.
But I waited till the jury was sworn, and I did that,
Okay.
I mean, intentionally, because jeopardy attached. So.
Sure. Yeah, and if it is already in writing, I'd love to have that. And
I will send it to you.
I assume this
this-
got argued at one point before if the
Yes.
prior judge made a ruling. So if there's a written response from the state, point me to where I can find that as well. If there's not, point me to where, like what date it's argued.
I have the order,
Okay.
and I filed that in a motion that I gave to this honorable court.
Okay.
I'll get the motion, I attached
right.
it, but I didn't give you my brief. So with the court's permission, and of course, the state has it already, but I'll resend it.
Is it filed in the case somewhere or?
Went to the Court of Appeals.
Okay, that brief.
The whole-
Yeah, sure.
the whole brief.
I'll take it all.
Okay.
And
there's-
then I'll assume the state filed some sort of a response, maybe not this team right here, but,
They-
and it may have been that more about that was about collateral order or not, but I'll take it for, and read it for whatever it's
No,
worth.
the state argued, and then they wrote the proposed order, which was signed by Judge Glanville. So,
Okay.
and it's a long order, it's
Yep.
12 pages.
I'll take all of that.
Okay, so I thought that would be, if you grant it, it would be helpful because it would knock out all this work.
Yeah, it would. That is true.
Okay, thank you, Your Honor.
Thank you.
I'll get you that brief.
All right, appreciate it.
Your Honor, I'd also point the court's attention to the transcript dated December 11th, 2023. It was filed on that date
Okay.
of at least one of the hearings where we addressed Defendant Williams' general demurrer claims.
Okay. Is it a transcript from December 11th or was it filed on December 11th?
It was filed on December 11th. It was
From-
held on November 20th, 2023.
Okay. Okay, thank you.
And it was specifically as to Defendant Williams' plea and bar / motion.
Great, thank you. Appreciate that. All right, Mr. Harvey, you look like you also were maybe going to stand up and come up with something we could do. Oh, and you know what? Hang on, sorry. If I don't do things when I think about them, sometimes they escape my mind. So I understand that for Mr. Williams, that is count 1, count 56, and count 57 you're alleging are fatally defective. And you mentioned that may be true about other defendants as well. Are there other defendants who either have already made or intend to sometime before this goes to a jury make a similar argument with regard to counts that you have against you? Oh, right. Yes, the Harvey rule. Thank you. Okay, but if you are all joining in, can you tell me, is this essentially true about every one of the gang counts that they're missing? Okay. All right. Then I can sort out for myself which ones go to which person. All right. Now, Mr. Harvey.
And this is more of an afterthought. At least I'm still having thoughts, whether they're before or after. I want to make an oral motion at this time
Okay.
to prohibit the state or anybody else from talking to witnesses while they're on the witness stand. Judge Glanville would give an instruction which was incorrect to witnesses. Don't talk to anybody but the parties in this case while they were on the witness stand. The only one that is, the only people that are accepted from the no talking rule once a witness is on the witness stand is a criminal defendant and the defense lawyer, because that's a Sixth Amendment impediment. The case, as I remember it, is Perry versus Leak, Perry versus Leeke. It is a United States Supreme Court case, which indicates that other than the defendant, witnesses or parties are generally prohibited from talking to witnesses once on the witness stand. So I would like an instruction. I could write this out. I can ask for an instruction.
That'd be great. I know you don't have to write out the motion. I mean, it's fine. I'll entertain it orally. And I mean, that's generally my understanding as well, but it's been a minute since I've practiced. It's been a minute since anybody raised that issue. Is there some kind of an exception for I mean, I know if you're on the stand and then we take a lunch break or a restroom break or something, that's one thing. Is there anything about overnight that is different?
Only for the defendant
Okay.
and the defendant's counsel. That was the whole basis of Perry versus Leak.
All right.
The state said in Perry versus Leak, hey, you can't talk to your client while he's on the witness stand. And the Supreme Court said that yes, because there were Sixth Amendment implications, that a defendant and a defense lawyer could, but generally other witnesses could not.
Okay.
So you're
Hazy
close.
memory.
Yeah, yeah.
All right. Does the state have a response?
Your Honor, I believe that the rule that Mr. Harvey is referring to essentially is the rule of sequestration, and as it relates to other witnesses and about talking about the witness on the stand's testimony. The reason I was looking feverishly is that Ms. Hilton and I had actually discussed this, and I had sent her a case,
Okay.
not from within Georgia, but it literally spoke directly to it. So I was at
Okay.
least looking for that.
All right.
Because I don't think that under the rule of sequestration that attorneys, I think that Judge Glanville had it right, attorneys are not prohibited from speaking to witnesses, but I want to make sure that we get the law.
Let's
to the court.
make sure we get it right. So I'll submit whatever you want to submit on that as well. All right. Thank you all. We're going to take a recess right now if there's not anything we can do immediately. And we will be back at 3 on a Rule 22 matter. Y'all got that notice, right? That there was a new Rule 22 filed? Okay. All right. Where's Ms. Bumpus? That's who filed the Rule 22. Afternoon. Right. So you filed a Rule 22 at what, 11:10 or so? That's fine. The night before last. So, and you had said that you wanted to start recording for yesterday. And honestly, I didn't even know you had filed it until we were finished with the court yesterday afternoon at 4 something, because it came in so late. And normally the Rule 22s go to our public information office, but I know about it now. And so I have provided notice to all of the parties, and I will listen now to, or ask if there is objection from any of the parties or witnesses or victims to the Rule 22 filed by Ms. Bumpus. All right. So I am not real. So what are you looking to do?
And I just want to be able to record what's going on in the courtroom.
All right. And you had already, I guess, yesterday live streamed from somebody else's
Yes,
live stream. What is that person's name?
Miss Sylvia.
Miss Sylvia.
Yeah, she's sitting in the courtroom.
Okay. All right. So there are an inordinate number of separate Rule 22s in this case. Anyway, I'm not really sure why everybody's not using the pooled media that is already, I mean, it's like 8 or 10 media organizations are using one pool, and then there's Miss Sylvia who has a separate one, and then lots of people who have the ability to take still photography and audio, and it's just a lot. It's like 8 or 9 different things. But I am not sure that yet another person doing essentially the same thing adds to the public's access to this proceeding. There is 24/7 coverage of this, a pooled camera, and Miss Sylvia's separate video recording that you can access anyway, apparently. So, I mean, if you want to be heard as to how that either increases the public's access or helps with the dignity of the court or the administration of justice or the truth-finding function of this proceeding, I'm willing to listen to what you have to say.
Your Honor, I'll be brief. I just would like to say that at any point, these other people who are part of this pool, they have logos and they can pull what I am streaming on my personal YouTube and do copyright is they have their own logo on there. And also, I don't always want everything that they are streaming. I don't need the full court hearing all the time. There are specific parts that I need to reference and informing the public of what's going on. And that's my point of being here. And I'm just trying to do everything right so that I can, pass the smell test.
Okay, so with regard to, I mean, obviously you can let the public know anything you want to, and you can video blog, vlog, all you want to, any kind of opinion that you want to about the case. And you can obviously also sit here and watch all of the proceedings. Are you saying that you can't use somebody else's, like the news media coverage?
It has their logo on it. At any time they can say it's copywritten and take it from
Okay.
from my page.
Have you asked anybody other than, is Miss Sylvia okay with you using her Because honestly, it's a little bit disruptive to have essentially phones in court. I mean, it ought to be that unless you are somebody who has a Rule 22 already in effect, or you are an attorney in the case, you shouldn't have your phone out or on or anything. And it's kind of chaotic in this entire part of the courtroom. And I find it to be distracting. I find there to be security concerns with having to constantly figure out, okay, who's authorized to have their phone out, who is not. And so what I would like is, until there's some point when you find out that you're not able to use somebody else's, what they've already taped. I mean, I'm kind of saying, why don't you and Miss Sylvia be the second pool? Okay, would that work?
We'll try it out.
Okay, so let's do that. Y'all are now the second pool.
You will revisit it if I have an issue.
Sure.
Thank you, Judge.
All right. Thanks. All right. Anything else we can do today? Or did I give everybody enough work that y'all can just go home and do your work? And y'all gave me plenty of work to do also. All right. So we are adjourned for the day. How about we see each other at 9 in the morning? Which doesn't mean when we get the jury back. If we get the jury back, I will go back to 8:45. But let's see each other at 9 in the morning, and let's be ready to actually work on some actual evidence, okay? All right. Are we going to be able to, so y'all are getting some of the transcripts of Mr. Copeland's testimony so far. What all have we already shared? No? We don't have any of his testimony? I thought we had at least the 11th. When are we getting that? By the end of the day? That was a really good question, Mr. Sharp. I thought we were going to be doing Mr. Copeland's evidence tomorrow, but maybe not.
Did we ever get an answer as to whether or not we have the transcript from the 10th? I know that Ms. Weaver indicated, excuse my seat, Ms. Weaver indicated that she was working on the one for the 11th. She might have it by the end of today, as well. I heard earlier, but you asked whether we actually had the 10th, and I didn't hear the answer to that.
The answer to that is no, we do not yet have the 10th. We had portions of the 10th, but they were the other portions of the 10th. So hopefully by tonight, the court report will have both the 10th and the 11th. Y'all should have, now this isn't his testimony. This is y'all going through evidence, but you should have a rough of the 18th, the 21st, and the 24th already. And then the rest of it will be forthcoming. So I don't know if we can work on Mr. Copeland tomorrow or not. I don't know what can we work on tomorrow? No point getting together, as much as y'all are all delightful. No point getting together if we can't get work done. The 18th, the 21st, and the 24th. No, so yes, that. So he testified on the 10th, the 11th, and the 12th, and wow, okay. He testified the 10th through the 17th. And then y'all took up matters about the evidence surrounding him the 18th through the 26th. All right. I think tomorrow might be more productively spent with everybody working on the things they need to work on. Tomorrow is Thursday, so let's get back together on Friday at 8:45. Okay. See everybody then.